the empty seat.
Yeah, it is. Oh, did they?
Thank you.
Oh, wow,
I
that's
get to
smart.
sit next to Joe Carroll, too.
That freezes you or makes you sick and be quiet. Highlander. Oh, yeah.
They treat me bad.
Okay.
And Jeffrey had me jumping.
You have any handouts or anything?
Good morning.
How you doing today?
Good. I don't think we're going to have as much excitement though as we did the other day. You have copies of
Don't look like it.
Everybody does.
Unless the guy sent the women to complain. I thought this was what he said.
And then if he wants to discuss.
It will be a way and a means.
The rest.
The Public Safety Committee meeting is now called to order. Mr. Clerk, would you please call the roll?
Alderman Bosley.
Present.
Alderman Schmidt. Here. Alderman Boyd.
Present.
Chairman French. Alderman Vaccaro.
Present.
Alderman Arnowitz.
Present.
Alderman Carter.
Present.
Alderman Carter.
Present.
Alderwoman Ingracia.
Present.
Alderwoman Green. Chairman Kennedy.
Here.
President.
Okay. Today we'll be discussing Board Bill 208. The plan is not to call for a vote today, but to discuss the various provisions of the bill and have questions answered by its sponsor from members of the committee. The sponsor will also be able to talk about his thoughts for further changes in the bill, but we'll be discussing the original bill. Then after that, if there are other committee members have any thoughts about proposed ideas for changes, we can discuss those as well. So this is not a meeting for public comment. It is for the committee, a regular committee hearing. Alderman?
So Mr. Chairman, I thought you were the sponsor.
No, when I became chair, Alderman and
Okay.
Yeah, we've already had public testimony, so this is a meeting of the committee itself to discuss the bill and any thoughts and ideas that we have in relationship to it. Alderman French, come right up front.
Good morning.
Good morning.
Do I need to make a motion that we take up 208 again? Or are we?
No, we already have. It's formally before us, 208.
Right. So Board Bill 208 creates a civilian oversight board for the City of St. Louis. State statute allows the city to create a civilian review board. Many people have been working for years to create a civilian oversight board in the City of St. Louis. I think many of the events that we've seen over the last few months show that we are really at a historic time in the City of St. Louis. We have a community that is in many ways divided. Faith and trust in the way we police our communities, I think, is near an all-time low. Faith in local governments to be able to act on behalf of citizens and be responsive to citizens, I think, is at an equal low. We are now at a point where many people want action. And so I think it is our responsibility to try to be responsive to those demands and calls for change. Board Bill 208, we can go through page by page. It does many things. It sets up a civilian review board that is, I think, in some ways less independent than many would want. We heard from testimony at our last meeting that there are those that want much more from the bill, and then there are those on the other side that think it already goes too far. For those of us that think that we are beyond the events and the fires of 2014, I think we were reminded last week by the actions of some in this room that we are still very tense, and the mood right now is still very much at where people are very angry and frustrated. And we want to try to do something that helps bring folks together. that helps add a new sense of accountability and restores people's faith that people will have equal protection under the law, at least here in the city of St. Louis. The membership of this committee in the current version of Board Bill 208, the way it is decided is the city is broken down into districts. And I'm on page 7, line 1. It creates 7 districts in the city of St. Louis. Each district shall be comprised of 4 aldermanic wards. The aldermen from those 4 wards will work together to nominate a member for the board. Those members are then, those names of those members, those nominees are submitted to the mayor, and it is the mayor who will decide the membership of this board. Now on page 8 of Board Bill 208, it says that within 30 days of receipt of the recommended names, the mayor shall deliver to the Board of Aldermen nominations for the COB positions. At which time, when he nominates those members, it is up to the board to confirm those members. So in this form, there is actual confirmation authority from by the Board of Aldermen. But if you go on under that section B, it says that the mayor may nominate any qualified person to serve as a COB member for that COB district. However, before nominating a COB member, the mayor shall consider for nomination any individual recommended by aldermen in the respective COB district. Now, the concern of many is that that says that the mayor really only has to consider those nominees from those districts, but at the end of the day, the mayor can actually appoint who he or she wants to. That is one concern in the current language. There are many different versions of civilian oversight boards and civilian review boards across the country. More than 100 cities have these. There are stronger versions and there are weaker versions. One thing to always keep in mind about the version that we are considering here in the city of St. Louis, is that it does not have the authority in any way to discipline officers. Its only power is to conduct independent investigations. That is the only benefit of the COB, is to be able to conduct independent investigations. And so there's a thinking, and I am one of those who believe that if we are going to make any benefit, receive any benefit from the COB, that we have to give it the authority to do a thorough independent investigation. At the end of that investigation, all the COB can actually do is still recommend changes or make recommendations of any kind to the chief, who would still have to do any kind of discipline or choose not to. The authority still lies in the chief of police and the mayor. Page 10, section 4, the authority and duties of COB. The COB shall have the authority to receive complaints, monitor IAD and its Internal Affairs Division's investigations regarding complaints, and review IAD investigations regarding complaints in accordance with the provisions of this ordinance. So what that says is that the COB just has the authority to receive the complaints, monitor internal affairs investigations, and review completed internal affairs investigations. Further on, under the independent inquiry section, it does allow, in some cases, for the COB to do its own internal investigation, but it's still very much reliant upon the Public Safety Department. In fact, in the current version of the bill, all the staff, including the director of the COB, is assigned and selected by the Public Safety Director. So it is still very much dependent upon the executive branch for its resources. And again, it cannot discipline any officers. Only the executive branch can do that. Further on, under on page 14, under section 5, under administrative structure, you will see, to that point, the public safety director, with the approval of the COB, will assign a staff member, that's a member of the public safety director's staff, to act as the COB executive director. The COB executive director shall assign investigative and administrative staff from the Department of Public Safety necessary for the COB to adequately fulfill its duties. Investigative staff shall not be current or former commissioned employees of the police department, nor shall any such staff have an immediate family member employed by the police department. The COB may delegate to staff the performance of any of the COB's duty, except where this ordinance specifically requires the COB to act by a majority vote. The Public Safety Department shall provide office space and meeting space for the COB. So again, if one of the benefits that we want to see from this is a thorough, independent investigation, there are questions about how independent it could actually be if all the staff are appointed by the Public Safety Director, who is appointed by the mayor. So one of the things that we hope to do with some changes in a proposal for a committee substitute that you'll see in a moment, some of those suggestions and proposals to strengthen the COB would be to add more independence to the body. And so the COB is not left only to the executive branch and the public safety director and therefore the mayor's office to staff, to hire staff, to hire investigators. There should be a certain amount of independence and separation between the executive branch, the mayor's office, and the COB in order for it to actually have an independent investigation that people can have faith in. There are several protections in here for officers. The COB in the current version of 208 did not have subpoena power, is not authorized to sit in on internal affairs investigations or interviews with the accused officer. Any information that it is getting actually comes from the police department, and the COB can only request information and is left subject to what the chief would want to turn over. Without subpoena power, they are really left to the whim of the police chief as far as what information they get to be able to conduct their interviews. Without independent staff, it is really the public safety department employees which are conducting the day-to-day work of the COB, and the COB is really left subject to those appointees from the mayor's office and the executive branch. So one of the things we really hope to do is to be able to add a level of independence. Many of you all remember several years ago there was a version of a civilian review board that was passed by this board. In that board, the feeling back in 2005 or 2006 was the same, was that in order for the Civilian Oversight Board to be effective, it has to be somewhat independent, and it has to have the ability to conduct a thorough investigation independently of the police department. In that bill, at that time it was Board Bill 69, it also sought to give the board subpoena power. At that time, at the time of a police board appointed by the state, the way that the sponsors felt that they could do that was to add language which said, and I quote here, "The commission," and that's referring to the Board of Police Commissioners, "shall use its subpoena power on behalf of the board," so that's the Civilian Oversight Board, "upon a majority vote of the board's members to compel the attendance of witnesses and or to require the production of such records and or other materials that are necessary for the investigation of complaints. The commission shall act to execute this subpoena request." Most people around the country who have followed these attempts to add civilian oversight boards will tell you, without subpoena power, without the ability to conduct independent investigations, there isn't much faith in the results of these investigations. And at the end of the day, that's what we're trying to do. we're hoping to restore people's faith in the system, restore people's faith in their police department in the city of St. Louis, and to make sure that people feel that they have equal protection under the law and that their complaints will be investigated fairly, independently, by a third party. The days of leaving it up to the police to simply police themselves, many people feel, and I'm one, that those should be over, that there should be a level of independent investigation when it comes to these complaints. The situation we have today, where people who should be natural allies with the police are afraid to call the police because they fear that it may result in the death of a young man or a young person. The situation where we have communities that are suffering from crime that should be cooperating and working with the police to help make our neighborhood safer, that in fact police and the members of the community are yelling at each other, screaming at each other, past each other. In fact, in the middle of City Hall, fighting with each other. I think that shows that we have to do something, and we have to do something serious with regard to reestablishing that faith and that trust. And I think a strong civilian oversight board goes a long way to making our streets safer and to restoring that faith that people should have in their police department. I'll take any questions on 208, if anybody has any questions about 208.
Alderman Bosley, any questions?
I'm very interested in what the people have to say.
Okay.
I want to hear that first.
Oh, yeah, we're not taking public testimony. We've had public testimony. Yes, sir. No questions right now. Alderman Schmidt, did you have a question, Alderman Bosley?
No, I'm just listening.
Okay. Alderman Schmidt.
Not so much, I think, Alderman, on this initial bill, the Board Bill 208. I've been a supporter of having oversight, and obviously the devil's always in the details, and as you outlined, there are a lot of different methods and types of these oversight boards. This appears, at least the initial 208, appeared to me to be a hybrid of a number of things, and sort of like a Swiss watch, kind of carefully calibrated in a way to acknowledge some of the state laws and charter provisions that we might have, recognizing that at one point we did have a Board of Police Commissioners that many claimed at least had the authority for some sort of oversight of the Internal Affairs Division and the police chief. And also recognizing that some would probably prefer no oversight whatsoever, and others would probably prefer to have some sort of either appeal process or parallel process with that. And so we ended up with the original Board Bill 208. So I am interested at obviously hearing perhaps, if we get to that, some of the proposals for some changes. I think that there are some in there that may be helpful, and obviously some that might disturb the that careful balance that has been there, so that probably no one is entirely happy with the original Board Bill 208, and yet it's something that we might be able to do with greater speed. Frankly, we needed something a number of years ago. Would have been much more, and I know you agree with this, something that would have been much better for us rather than doing it in the tumult of current affairs. We might have had something in place that could have been working with the police commission, and then there could have been a natural sort of progression from that. So I appreciate the outline of that. I think that what I heard the other night is that a number of police officers would rather not have yet another level of oversight, that there are some folks in the community, and I know that I have some people in the community that would probably like to have independent investigations of each and every situation, and yet we've come up with something that seems to be calibrated to satisfy none, and yet doable, so that we can get something done pretty quickly that we think is going to pass muster, because at some point it'll probably be in the courts, and we want to make sure that we do have a process that can be done so that people can have that faith restored. I agree with you. So,
Alderman Boyd.
Yes, good morning. Thank you, Mr. Chairman. I just have one question. When you look at all the different models across the country and you could pick the top 3 cities who have civilian oversight boards, what would those cities be and what makes their models the best model?
So, like I said, there are many cities that have these boards. Even in the state of Missouri, Kansas City has one, Columbia has one. One of the ones that, at least the model, I think, was very nice was Baltimore. It has subpoena power. It is appointed by the mayor. But even when you look at the results, since Baltimore has established it, even though the legislation itself was one that I would really have liked the city of St. Louis to model, many people feel it's ineffective, not effective at all. They had not been able to get qualified people to be on the board. I think they had 7 seats. 3 have been vacant for years. The 4 remaining have served over their legal term. It's just not something a lot of people want to do. As you know, we're all members of a board here, and it's tough work. And if this board is expected to receive as many complaints as we think it might per year, it is unpaid. They would have to meet often, and it sometimes is a tough thing to find people to sign up to do. The other thing is that when you create any kind of board that is appointed, even if structurally we provide a very strong board and the mechanisms for it to do independent investigations, there's still 100 different ways for the appointing authority to get it to have the result that it wants to have. And so the thing we find ourselves at is that even as we fight for a strong version of a civilian oversight board, it is still not in any way outside of the control or influence of the executive branch, who ultimately makes the appointments. And so it is still a cooperative effort between the legislative branch and the executive branch, and it still relies upon both parties in good faith wanting to have a level of oversight. And so there are many models, but the model alone without the will of the appointing authorities and the attention of citizens to keep holding even that board that we create for accountability, even keeping them accountable, nothing is perfect. And you can see, you've seen different versions of them actually slip into irrelevance.
Right, but I'm just curious, there has to be a city out there somewhere where they've created this and it has shown to have a positive effect in the community and have bridged the gap in some kind of way with the citizens and the police department. Are you aware of any out there?
Yeah, I think Baltimore, when it was first done, was good. New York City has done one that is a very strong and thorough board, but even in New York City, as you'll see, the people are very not satisfied. And so civilian oversight boards in and of themselves will not solve the problem. But it is an additional way for independent investigation to be done. In fact, most civilian oversight boards you see wind up agreeing with the internal affairs investigation over 90% of the time. In the case of Baltimore, it's 96% of the time. So, but still, there is that opportunity for people to have an additional entity to look into their complaints and to make them feel that it's being taken seriously. But I think, again, one of the things that we need to move forward, and this is what all the cities who do it are trying to do, is not leave the impression that it is just up to the police alone to investigate themselves. Mm-hmm. And I think, as we've seen, that sets a bad precedent. It has a bad result.
The curious question I had, as we look at how they're appointed and we're in clusters, was there any consideration for like at-large members and members that have specific qualifications, i.e., is it an advantage or disadvantage to have someone who's been a police officer, lawyer, any a criminologist or anyone involved in law enforcement that would kind of provide some guidance or expertise to the board in some kind of capacity?
Yeah, I think that's a good point. There are other versions of civilian oversight boards that specifically say you need to have a certain number of members who are have law enforcement experience. Some even have non-voting members that are from the police union. And so I think many of the folks who worked to craft this bill tried to find a medium, and I think the medium that they had was that very few restrictions for who could be on it, but ultimately the mayor would decide, and so that would be the check and balance. In the proposal that you have on your desk there for committee substitute, there are added provisions, and this is based upon some of the testimony from some police officers who came to testify last week, that they wanted to see certain additional requirements placed on who could serve on the board. And so one of the things we did was raise the age limit from 18 to 25. We also spelled out that at least 2 members must be lawyers in good standing with the state of Missouri and licensed. So at least it would have a certain level of legal expertise on the board. It would ensure that. So those are some additional requirements that we did add in the proposed committee substitute, taking into account some of the concerns and statements from law enforcement.
Okay, thank you. No further questions.
That completes you. Okay. Alderman Vaccaro.
Alderman Morris.
Alderman Moore's not on the committee.
Oh.
That was raising me.
Morning.
I know one of the things you said is by putting this in place, it'll reduce crime. I know that city control was supposed to reduce crime. I'm just curious how this particular bill will help reduce crime.
No, I don't think I said that it directly reduces crime. Well, what I do think it will do is if we can restore that communication and that improve the relationship between the community and police, it will lead to safer neighborhoods. I think one of the things that we've always had a problem with is a certain level of cooperation and trust for the police department, with the police department. And that's just gotten so much worse even in the last few months. And so, what I've noticed, for instance, in my neighborhood is, again, many of those folks you would think would just be those natural allies, senior citizens, clergy. They have become less trusting of the police. They have seen some of these events of the last few months and have told me that they now think twice about calling the police. That is an emergency for our city. That's something we have to deal with. We've seen the high rise in crime. We've seen the increase in violent crime and homicides. The friction between the community and police is having a negative impact. And I think anything we can do to help ease that tension and to restore that trust and faith will eventually lead to reduced crime.
Okay. I mean, the only reason I was asking again is, and I know I brought it up before, and it has to do with my little brother in the Big Brothers program who had someone shot and killed on his lawn. And I don't think he was afraid of the police or his family. I think they seem to be afraid of the people that actually did the crime, more so a fear of retaliation from them. So I didn't see how this would make any difference in,
well, let me tell you,
because I think there's more fear of calling the police for retaliation from the people doing the crime.
True. And one of the things that I often hear is that people are afraid to call the police because they feel that the police will sometimes let folks know who called the police. And we've all had, those of us in neighborhoods have had that situation. And it only has to happen once or twice, and you have somebody who will never call the police again. And so that's a problem. I think what we need to do is try to reestablish this feeling that police and folks in the community are in it together, that we're all trying to make the neighborhood safer, and it's not a them versus us attitude. And I think, unfortunately, some of the statements that we've seen, especially from some of the union officials over the last few weeks, have reinforced this them versus us attitude. And that doesn't do anybody any good. We have to be in this together, especially if we're all trying to make our city together safer.
And on this, and well, the committee sub too, because I know that had you talked to the different, like, I know we've talked and we had people from the community in. Has there been talks with the police about this, and have they had input into this to how we can better get this all together? And, you know, because I don't disagree with what you're saying, but did they have a lot of input or say on how this was put together?
So the construction of Board Bill 208, the original version, has been going on for many months, and there's been conversations from lots of different folks. And even though the current version by some is considered weak, it still had very strong opposition, as we saw last week, from some members of the police union. This new committee substitute, the process, I think, is to put it all on paper, put it in writing, and allow the board and others to comment and discuss it. The chairman said we will not be voting on this today, and so I expect many conversations to be had over the next few days, and more input offered about changes. Amazingly enough, this is one of those subjects where no matter what you do, some people say it goes way too far, and some people say it doesn't go nearly far enough. But we'll try to get something passed that at least will do what we want it to do, which is to be a step forward in trying to restore that faith.
Okay, thank you.
Alderman Ornowitz?
Thank you,
Any
Mr.
questions?
Chairman. I know that, Chairman, you actually was working on a bill since 2006, correct? And the version that you came up with, everyone's not going to agree on everyone's version no matter what it is. But I think your version is actually a good start to it. At least we get the dialogue that we're talking and everything. No matter what comes out of it, everyone's not going to be happy. And just to say this, Alderman, people say this bill doesn't have enough in it, it has too much in it, this, that, and everything else. Believe it or not, there are a lot of policemen that don't have a problem with a civilian review board. I think the fear of the police officers is because it's, like you said, it's them against us. The fear is it would be something new. You don't give them too much overpower as it gets acclimated as it goes along, and start adding different things in there. This is new. Not every city has it. A lot of cities do have it. So I guess this needs a lot of room. I think we as a Public Safety Committee now can start more discussions and try to finalize something we can all agree on. As well as me, there's over the last few months, the events and everything. But again, the only thing this won't do is, and I heard you say maybe this will bring communication lines open together. It saddens me when I read about a grandmother walking her grandchildren and is gunned down on the street walking them. Now, my God, it's a grandmother. Somebody had to see something. If they did see something, you got to start stepping up as a community, and there is, I guarantee you, there's some police officer that somebody trusts that they can give them information to. I mean, that's just my and maybe there isn't. I don't know. But I know when you see grandmothers getting gunned down, a 4-year-old girl getting shot, and this, and nobody wants to step up when there's witnesses, that's terrible. It really is. So the community really needs to work together with the police on a lot of things, even though you may have different feelings on different thoughts, because you're talking about people's lives. But I think here what you're doing is open a dialogue up for us to have more meetings and try to solidify something that everyone can agree on. And I appreciate you doing that. It's not something, as you well know, that we're going to get done overnight. It's going to take a joint effort from everybody to work on a bill and put together that hopefully 90% is agreeable on. So, and that's all I got to say. And I do applaud you for trying to put something in there so people feel like they have more say so, and they're being heard. You know, we all need to be heard as citizens. We all need to be heard as police officers, firemen, city. We all need to be heard somewhere along the line. So, and I do appreciate what you're trying to do, and I think it's great that, you know, with the chairman's original bill, now we can have some more meetings and start really working together and moving forward.
Thank you. If I can
Yeah,
comment one thing, is that so as you mentioned, yeah, many officers are not threatened by this at all, because many of the officers that I've talked to recognize that at the end of the day, the Civilian Oversight Board, in both versions of the bill, cannot discipline officers in any way and doesn't have any direct authority to fire, discipline, dock pay, any of that. The only benefit of a Civilian Oversight Board is that it can give an extra set of eyes, independent of the police department, independent of the executive branch, independent of those that work closely and may have a conflict of interest, to be able to do an investigation and then turn those recommendations over to the chief. And so, no, I don't think any officer should be threatened by any version of the Civilian Oversight Bill. Because at the end of the day, it just allows the community to have somebody else to go to, not leave it just up to those who may have a conflict, to get an extra set of eyes to do a thorough investigation and then turn those recommendations over to the chief.
Okay. Excuse me, we're not having any. No. Alderwoman Hubbard.
Thank you. Thank you, Mr. Chairman, and also to the sponsor of the bill. I have some comments and some questions regarding the bill. First of all, to be perfectly honest about it, I thought that it was our mission as a body to create something that would enable us to get it through within the confines of the framework that we're working in. And when we initially had those meetings, I mean, you know as well as I do that subpoena power was not in that, because we understood that it would be met with resistance. And looking at our numbers, and clearly the chairperson had been working on this for years before either of us, me or you, had gotten here. And so when we get this, you know, at the last minute, and we're trying to wrap our heads around it, and I believe that everyone in this room goal is to get this done, and then if we need to come back and change the charter or do whatever we need to do, then there's a process to that. So, and definitely you pride yourself on getting advance notice on things, I mean, even with anybody's bill. So when we have this before us, and I'm thankful that we're not taking a vote on it today, it's met with some concerns from me. And specifically when we look at the process as to the appointments, the structure that I see, I think.
Are you referring to the committee substitute?
No, well, yes, I am. Yeah, the committee substitute. But in the initial bill, before we got to the committee substitute in regards to the appointments, which will be comprised of different districts, and then it went on to state that if the board reduced, then you know, we will make adjustments to that. I think that, you know, it's shameful to suggest that if a person is appointed after they've gone through this process where their alderpersons have put their name in the hat and supported it, I think it's shameful to suggest that if they're appointed, then they can't think independently of the person who appointed them. I mean, if that was the case, then that would dispel the structure of almost every appointed position ever. And so to say that, you know, I just hope that as a board, you know, we can get past our own personal political issues or whatever and do what's in the best interest of the city and our people who are dependent on us as leaders to move things forward and to get something done in light of the last 6 months what we've endured. So, secondly, in regards to subpoena power, I would just like to know if there are any other models out there that will show the pros and cons of having this in place. Of course, let's be perfectly honestly with the body out here. We know that if we put that in there, it's not going to pass through the board. And so what we're trying to do is to address everyone's needs and really, you know, get a handle on this horrible situation we have ourselves in as a city. So with the subpoena power, I mean, if you were to add that in there, do you think that, and I'm glad you added it in that some people would have to be lawyers and stuff, but speaking as a person with an advanced degree in criminology and years of experience in law enforcement, I wouldn't want to sit on that board and act as if I'm authority on their process or attempt to micromanage their process when I feel that there are already checks and balances in place to assure that some things go in the right direction. Now, I know, there's a lot of distrust and there's a lot of lack of faith in that process, but my concern is that if, as a body, we're trying to do something to help the people that elected us to represent them, why throw this in the hat when you know it's going to get shut down? And that's my question to you. And you.
Yeah, I'd like to intervene in here. If we could keep right now to the original Bill 208, and because he's going to bring up the point, the other proposal, and then we can get to your question because that particular question is in the committee sub.
Correct.
So if you can hold on just that question. Okay. Was there any specific question on 208, the original?
Specifically, can he explain to me what other models that are out there that have used this process similar to what this bill is suggesting in regards to the different districts and the appointing authority of the mayor? Can he delve into that for me?
Okay. So a couple of things. First, your first point was about the appointment process. The appointment process is described in Section 3 of the bill, specifically pages 7 and 8. You're right. Under the current version and current language of Board Bill 208, there's a nomination process. The nomination process, as described earlier, is the city is divided into COB districts made up of 4 wards each, and those aldermen from those 4 wards recommend a name to the mayor. But as I pointed out before, under the existing language of Board Bill 208 on page 8, lines 5, 6, and 7, within 30 days of the recommended names, the mayor shall deliver to the Board of Aldermen nominations. Despite the nominations, the mayor may nominate any qualified person to serve on the COB and for that COB district. However, before nominating, the mayor shall consider for nomination the individuals recommended by the alderman. So in the existing language, even though we have this nominating process, there's language that the mayor does not necessarily have to follow that.
So are you suggesting that that language is too loose and may need to be more defined and more specifically state how that process needs to work?
I would suggest that if we do have a process and language that goes to the trouble of creating the sub-districts and creating a nominating process, that we should at least say that the mayor can only nominate folks that come from that process. But to say we do all of this and that the mayor can still go around that and appoint who he wants, I think only acts to give the appearance that we have some due diligence going on, but in fact, at the end of the day, he can appoint who he wants. And I think that's damaging. The other thing that was raised, not just by you, but by others, was this idea that let's just do something. And I'll point out that there are different municipalities, including most notably the city of Ferguson, that pass things called civilian oversight boards just in the name of doing something, but in fact are very weak. And in the case of Ferguson, at best you can describe it as a civilian advisory board. But without subpoena power, without the authority to do its own independent investigations, with all the members appointed by folks who would rightfully and logically have a conflict, then all you're doing is creating something in name only. And I would argue that that might actually do more harm. So, yeah. The third thing you mentioned was about subpoena power. And why include that? And I think you made the assertion that it would never pass the Board of Aldermen. First, I would remind you that subpoena power in the form of a civilian review board did pass the Board of Aldermen previously. So the problem with subpoena power in a civilian review board has never really been a problem with this board. This board has supported that in the past. The problem has been in the mayor. The mayor vetoed the previous version, and even yesterday his chief of staff made statements that if we were to dare attempt to pass a civilian oversight board with subpoena power that he threatened to veto it again. The fear of subpoena power has never been just in this board. This board has passed that previously. And I think in light of what we've seen over the last few months, I would argue that many folks are even in a better position than they were several years ago to support a strong civilian oversight board. But at the end of the day, the job of creating laws for the city of St. Louis is here in the legislative branch. It is the executive branch's responsibility to enforce those laws. And so I would hope that the mayor would have an open mind, and I hope that he would also recognize the importance of having a civilian oversight board that has the ability to do thorough, independent investigations, which is his only real strength. Without that ability to do a thorough, independent investigation, keeping in mind it does not have the authority to enforce its recommendation, hire, fire, discipline in any way, just make recommendations. I think that's the least we can do is give it the proper authority to do a thorough, independent investigation.
Thank you. So are you suggesting that there are no models out there that can be deemed effective without subpoena power?
No, and I will also note that subpoena power is very rarely used. In fact, this board has subpoena power, but I can't remember the last time we've subpoenaed any information. Sometimes just the very power to subpoena means that your request is taken a little bit more seriously. So I don't foresee in any way that, in fact, anybody that we do have given subpoena power to, including the committees of this board, don't go on subpoena rampages and just start going subpoena crazy. But it is important, especially if their job is to do, their prescribed job is to do investigation, that they are given all the information and that the information isn't just, that they just aren't dependent upon an entity that may have a conflict to supply all that information. I think that's a bad precedent, and it sets the board up to be weak and to set it up for failure.
And you personally believe that there is a conflict from that entity? You do? You believe that?
Sure. I mean, for the very nature is that by the time it gets to the COB to do an investigation, presumably the police department has done an investigation. The Internal Affairs Department has done an investigation. And so if the COB was to do an investigation that found conflicting information or found that they did not do their job properly, yeah, it could be argued that it would be in their interest to not allow that to be done or to not let them get the information that would show that they didn't do their jobs properly. And in fact, if you look at in the board bill, let me find the exact page, under independent inquiries, here we go. Page 21. It gives, in section D, starting in line 3, it gives, clearly outlines when an independent inquiry can be done. If the COB finds by an affirmative vote of at least 5 of its members that Internal Affairs Division failed to investigate a complaint, failed to properly notify and involve the COB pursuant to this ordinance, failed to follow its own protocols in conducting an investigation, or failed to provide the COB with findings and information as required by this ordinance, the COB may conduct an independent inquiry. So under the language of this, it would mean only under the circumstances that IAD has failed that they would launch this independent investigation. So yeah, I think if they've determined that IAD has failed to do their job and then to be left up to them to supply information, you know, you can see it would be so much of a conflict.
And so in the current system, is there anything that already addressed these particular situations where it has been deemed that the IAD has failed to do things properly? What's that system or that process as it stands?
In the city of St. Louis?
Yes.
That's it. That's it. So once the police department determines that nothing's been done or that nothing was done wrong, or IAD determines that nothing was done wrong, unless it's the rare circumstance that the circuit attorney would take it upon herself to look into the situation. That's where it ends.
Okay. No further questions.
Okay. Alderman Carter.
Thanks, Mr. Chairman. Do we know a cost or physical note on this bill?
No, as you are well aware, and we talk about a lot, our current rules of the board did not require a fiscal note on bills, so there is no fiscal note. The only cost would be in the staff for the board, and the way it works now under the existing language of 208, the public safety director would include in his public safety budget funding for the Civilian Oversight Board. Now, some might argue that also nips away at independence because they are relying upon the public safety director for their funding. But in the current version, that's how it works. And whatever that total may be, and actually whatever staff the COV would have would be dependent upon the budget number put in by the public safety director.
Right. All right. Well, I'm interested in moving forward to hear the committee sub. So I'll have more questions on that. But I think that we owe it to the citizens of St. Louis City to pass a bill that has some teeth and some meaning. So, I'm looking forward to it.
I'm going to ask that you refrain from clapping and the rest of that. This is a regular committee hearing, and we really need the opportunity for committee members to be able to discuss this and get through this material. So I'm going to kindly ask that you refrain from clapping or jeering or anything else while this meeting is going on. Not at this meeting. This is not the meeting for that. We've already had that. Alderwoman Ingracia.
Thank you, Mr. Chairman. Alderman French, I guess one thing I'd like to note is a couple people here have mentioned that, we are all in this together, and I think the report that Alderman from the 18th Ward kindly passed along to us from the Department of Justice outlines pretty specifically, as does a lot of the research, that the specifics of how an oversight board is actually structured is not as important as making sure all the stakeholders are at the table together. And I'm just curious whether or not the Police Officers Association has been involved in any of these conversations. I know we've got members from the activist community. We've had some members of the Public Safety Committee, the police chief, the mayor's office. They seem to be an important piece of the puzzle.
So in the crafting of Board Bill 208 over many months and years, the previous sponsor, chairman, can probably speak more to that, but several entities were at the table. And the changes to Board Bill 208 and the committee substitute is also a reflection of some of the comments made by members of the police union at the last meeting. One of the consistent themes that was in their prepared statements was on raising the requirements for people who would serve on the board. Some of their requests were more eloquent than others. Some of them specifically said educational requirements. But I understood what they meant, and so we did add the requirement that there would be at least a certain level of expertise on the board with regard to the law. So that requires at least 2 of the 7 members being lawyers. Also raised the age requirement from 18 to 25. And both of those changes were done based upon testimony from the police union.
Okay, and thank you for doing that. I did want to clear something up. I've heard a few people say that the police officers are against civilian oversight. The 3 members of the Police Officers Association who were allowed to testify before things got out of hand all said that they were supportive of it but had concerns. So I just wanted to make sure that that was a point of clarification. And then last comment, no further questions, is I would encourage all of you to read the Department of Justice report. It does outline Berkeley, Flint, Minneapolis, Orange County, Florida, Portland, Rochester, St. Paul, San Francisco, and Tucson as all places having successful civilian review boards, and they're all structured differently.
That completes you, Alderwoman?
Yes, sir. Thank you.
Alderwoman Green?
Just have a few, most of what I needed to say has been said already, and a lot more of my questions go to the committee substitute than to Board Bill 208. But there are a couple of comments that I have. So the purpose of this is really, to create a thorough, independent investigational unit that is going to add a layer of accountability to help us build trust between the community and the police department. I've seen it in my ward, people calling me and saying that, I'm concerned about calling the police because of what may happen, and that impacts our ability to fight crime in our neighborhoods when that is occurring. I don't think that this in and of itself will solve the community police trust issue, but I think it's a step in the right direction. The concern that I have heard from my constituents over and over and over again is about the selection process. And, not only is there this gap in trust right now between some in the community and our police department, but there's also a gap between people in our community and government. And so I think, one of the things we need to be looking at is how we create a selection system that gives more voice to the people in that selection system, so that it's really the people who feel like they are represented. Because as much as we want to say that we're elected to represent them, our people still have trust issues even with us sitting at this table. And so I think that's just an important thing to look at as we move forward. But that's where most of my hesitancy is with. I have received more comments about the selection process than I have about adding subpoena power or not adding subpoena power. And so I think if we're looking at what's going to, be the strongest bill moving forward that we can have support on, refining that selection system needs to go to the top of the list. So that's it. Thank you.
Then at this point, unless there are any other questions from members of the committee on Board Bill 208, we'll go. Alderman Schmidt?
I just thought about this. With regard to the policy issues, which is a whole other thing that they have input on, some feedback that I've received is trying to make sure that those are totally open to everybody, and that with regard to any privacy issues on a personnel issue, that those things might not be as public except for the final decisions and working through. Does 208 address that and make that distinction? I honestly don't remember if we made it clear that even though there might be some privacy issues with regard to personnel, we want to make sure that anything dealing with policy is totally open from the outset, from the get-go. And I don't know if that's clearly reflected in this or not. And you may not know the answer now, but that's something that's in my head now to kind of take a look at. So I don't want to lump it all together and say, hey,
Yeah, I don't think there's anything specifically saying that those policy discussions would not be open.
I understand.
The only language that refers to what is open and what's not is one that says that the board must abide by the Sunshine Law, and except in cases dealing specifically with personnel issues or specific complaints where personnel or sensitive issues may come up, that those may be closed meetings. And so I think by default then that policy discussions which don't involve personnel would be open, and the chairman could probably attest to that.
I agree with that. I'm not sure if it wouldn't be a bad thing to, in other words, it'd be a good thing to specifically make sure it's clear that anything that doesn't have anything to do with personnel needs to be totally open and people are involved in that process more clearly. It's just a thought, and that was offered to me by...
Is the question, can they make recommendations about policies, or?
The question is whether those discussions and recommendations would be public, required to be public. One of those meetings discussing policy.
I think we just need to think about that as we move forward.
Okay. Thank you.
Yeah, I can find the specific section.
Do you have another question on 208, Alderman Vaccaro?
Just a quick follow-up. I know you said that the two police that did talk said they didn't represent the association or the police department. Has there been any direct talks with the police association?
It has been.
What's that?
It has been.
There has been?
There has been.
Okay, that was the question. So even on the, we're not on the committee sub, but, so there has been.
There has been.
Okay, thank you.
The direct conversations with the police association.
Right.
Alderman Boyd sat in on one of those meetings, and several others before then, even through the mayor's office. There has been conversations with them.
Okay, that was the question.
Are there any other questions? If not, then we can talk about some of the thoughts in relationship to changes.
Sure.
That's outlined in what you put forward earlier. And I don't want to put the committee sub before us, because you're not going to be the only person to talk about thoughts, only committee person to talk about their thoughts and ideas. I'm not trying to put it before us. Mm-hmm.
Okay.
In relationship to your earlier discussion. Mm-hmm.
Okay, so I guess for the points of, unless the clerk has any issue, I think we'll just use Board Bill 2A committee substitute as kind of a...
Mr. Chairman, I'd like to do a point of order.
Surely.
It's my understanding that we would need the committee substitute before us to discuss it.
We do not have to put the committee substitute before us to discuss ideas on changes to 208. Now, if he wants to take, and I was not trying to go there at this point, to take that as a complete entity, we would need to have a motion to do so. So we're not really discussing committee substitute for Board Bill 208. We're just generally discussing thoughts and ideas towards changes.
Okay, thank you.
Sure. So then, for those purposes, then let me...
So we're not discussing committee substitute, just your thoughts and ideas in relationship to changes to 208.
Okay, so I'm going to go through 208 page by page and tell you what I would change. So on page 2, first of all, there's a slight typographical error, I think. Whereas participation by the public in the process of receiving and reviewing civilian complaints, the current version says by law enforcement officers. I think it was meant to be against law enforcement officers. Would be a small change. In section 2, under the definition of complaint, a similar thing. Complaint shall mean any request directed to IAD or the COB to inspect and investigate alleged misconduct. It says against members of the police department. I think it would be by members of the police department. Under the definition of independent inquiry, section I, independent inquiry shall mean COB's separate conducted examination of a IAD investigation, wherein COB, the existing language says request the attendance of. I would think a way to strengthen that would be just to say wherein the COB may interview complainants, witnesses, and employees of the police department. Scratch out in interviews. Also say access. Stripe out under reasonable terms, which I think adds uncertainty. So access records and physical evidence and other investigative and otherwise investigate citizen complaints pursuant to this ordinance. I think in the definition of independent inquiry, it allows room for us to strengthen that. So that would be an area I'd have some concerns. The next section would be section 3, the composition of the Civilian Oversight Board. This is where, in that section, where based upon concerns of law enforcement, I think we can tighten up and add further clarification and restrictions to who exactly could be on the board. One such request would be to actually require at least 2 of the members be attorneys, licensed in the state of Missouri in good standing with the Missouri Bar Association. It would also clearly spell out that the COB should elect 2 members to serve as both chair and secretary. Additional requirements you could possibly add in that section 2 would also be that in addition to be a resident, they would also have to be a registered voter. Instead of being 18, they would have to be at least 25. Another additional requirement based upon testimony and input from law enforcement is to also require that all board members follow, and this is some standard language from other civilian oversight boards across the nation. In fact, there are so many that there is a National Association of Civilian Oversight, that the members shall follow the National Association of Civilian Oversight of Law Enforcement Code of Ethics. In the section, the next page dealing with COB districts, I think it's important to note that if there are future changes to the number or location of wards, we've seen that in the past where awards, and Alderman from the 20th can testify that sometimes the number may stay the same, but the location of the ward changes. And then I think it should be more about the wards, not necessarily the aldermen, number of aldermen. Under nomination, the next page, that's section 6, subsection B. Under nomination, one of the things we talked about is that we go through this whole trouble of establishing a COB nomination procedure, but the existing language which says the mayor may nominate any qualified person to serve as a COB board member for the district. However, before nominating the COB member, the mayor shall consider for nomination any individual recommended by the alderman. In effect, what that says is that you can nominate who you want, but I can appoint who I want. So I would propose striking that. Rest are pretty minor things on the next, under confirmation, just cleaning up that last, on section C, that last part isn't really necessary. You could probably end at 30 days, a period after that. The next section, term of office, specifically saying at midnight is when the term would end on December 31st, just clarify. And it is in section 4 where we get to where the proposed meaty change would be, which is to add subpoena power. And under the proposed language, it basically would add that the board may issue a subpoena signed by the chairman of the board to compel two things: the attendance and testimony of a witness other than the accused officer. And that is very important, is that you still would not be able, and this is taken into consideration some of the concerns from the police and police union, it still does not allow the subpoena of the accused officer. And that has to do a lot with existing contractual and procedural personnel issues. So I think that is a concession there. And they can also subpoena for the production of any book, record, or other document. If a person fails to comply with a subpoena, if you have a subpoena, you have to have, if you have the authority to subpoena, you have to have a penalty for not actually complying. If a person fails to comply with a subpoena issued under the subsection of on petition of the board, a court of competent jurisdiction may compel compliance. So again, it would not be this board that would have an authority to discipline or fine anyone. It would be asking the court to do that in the name of this ordinance. The other thing that was also brought to our attention is that there was two things that several attorneys said that in order to be effective, this is what you actually need. You have to be able to subpoena witnesses, and you have to have them under oath. And so the other section added to this subsection would be the chairman or the secretary of the board may administer oath in connection with any of the proceedings of the board. All witness testimony shall be recorded. Penalty for false statements: any person who knowingly makes a false statement, report, complaint in the course of an investigation by the COB conducted under the provisions of this ordinance is guilty of a misdemeanor, and on conviction is subject to a fine not exceeding $500 or imprisonment not exceeding 6 months or both. Now, that's important because under existing language of 208, not only can they not subpoena witnesses or records, they can only request it, but even if they were to interview somebody or were to be given documents, there is no penalty for giving false information. So again, if the COB is to have any authority or any weight at all, there has to be a penalty for lying to the COB or deliberately giving it false information. Further down, findings and recommendations. Again, the only thing that this board can do at the end of the day is, after it conducts its investigation, which we hope to be thorough, and given full access to all information and appropriate witnesses, only thing they can do is to turn over those findings and recommendations. Under that section 4, findings and recommendations, the findings and recommendations of the COB and the basis thereof shall be submitted to the commissioner. We also added for discussion, now the commissioner is considered the chief of police. So not only is it submitted to the chief of police, we also added for consideration the public safety director and the members of the public safety committee. So that, again, if they can only make recommendations, and it's still up to the chief to either do something with those recommendations or not, in order for those recommendations to have any weight or any hope to actually see something being done, we felt it should not go just to the chief, and that by bringing it to the members of the Public Safety Committee, at least it would also have those additional eyes where people can hold to account the executive branch. Next section, under reports regarding implementation. The existing language says that the COB may request that the Public Safety Director provide information to the COB concerning whether the COB's recommendations were implemented. So under current language, even after they make the recommendation, it can just go nowhere, and that the Public Safety Director or the Commissioner, the Police Chief, don't have to make any, there's no language saying that they must give a report back on what was done based on their recommendation. So what we propose is scratching COB may request, and simply saying that the Public Safety Director shall provide information to the COB concerning whether the COB's recommendations were implemented. Under records, we propose scratching the added-on language that says, to the extent permitted by law. That is understood. The COB shall have access to and the ability to obtain copies of all records, policy statements, operational and procedural guidelines, and manuals necessary to perform its function. Now that's just basic. They have to be able to be given the information in order to actually make policy recommendations or recommendations on specific incidents. Without the information, it is really an uninformed opinion, and that is really what we want to avoid. And I think that also takes into consideration some of the concerns from police, is you don't want a bunch of uninformed people making recommendations. The way you make them informed is to give them the information. We added a section for meetings. Last thing we want to do is have a COB that never meets. So we had the COB shall meet as often as is necessary to perform its functions and duties, but it shall meet at least once a month. Under rules, there were several incidents throughout the bill where there were mays that we wanted to change to shalls. As you know, may is not a directive. Shall is actually law. The COB shall, instead of may, by a majority vote and after consultation with the department, with the Director of Public Safety, adopt rules and procedures that prescribe operating procedures regarding its meetings and administrative protocols, the manner in which it is to conduct inspections, provide findings to the Commissioner, inform complainants of the status of inspections, to fill other duties and responsibilities. So very basic is that we must have it where the COB must come up with its rules. And then add to that these rules and procedures shall be made available to both the public and the employees of the police department. It's important for everybody to know the rules, both the police and the public. The next section we looked at is section 5. I believe that is on page 16. So this is about independence. So under the existing language of Board Bill 208, under Section 5, Administrative Structure, the COB shall have staff, okay? including an executive director and investigators. I think that's actually added, some additional added language we looked at. It shall have staff, including an executive director and investigators. It can't be effective if it doesn't have staff. Approved by a affirmative vote of a majority of its members. And then the existing language also goes on to say the Director of Public Safety, with the approval of the COB, will assign a staff member, one of his staff members, to act as the COB Executive Director. I think that raises questions of independence. The COB Executive Director shall assign investigative and administrative staff from the Department of Public Safety necessary for the COB to adequately fulfill its duties. Again, if all of its employees are assigned by the Public Safety Director and are employees of the Public Safety Director, is a question if they actually are held accountable to the COB or to the Public Safety Director. Investigative staff shall not be current or former commissioned employees of the Police Department, nor shall have any such staff have immediate family member employed by the Police Department. Now that section actually I think is some of the supporters of civilian oversight have tried to make it as independent as possible. I would argue that some of that should be left up to the COB to decide their staff issues, and in fact you may want somebody who is experienced as an investigator. But again, if I understand having that, if those people are appointed by the Public Safety Director, you want to have that additional measure. If the COB is free to hire their own staff, I would opt to leave it up to the COB to hire their staff as they wish. The next section that we looked at was Section 4. Under legal advice and representation, this is again something that lends itself to the question of independence. The current language says that the COB and its members acting in an official capacity as COB members shall obtain their legal advice by and through the City Council's office, that is the mayor. So that the current language says that they must get their legal advice from the mayor's office. The City Council's office shall provide such advice to the COB and its members acting in their official capacity as COB members in a manner consistent with the Charter and with the applicable rules of professional conduct, including applicable conflict of interest rules. This ordinance shall not be interpreted to allow the COB or its members any rights to indemnity. The only thing I would suggest changing in there is to change shall to may. Leave it up to the COB to decide either to rely upon the City Council's office for legal advice and counsel, or to obtain outside counsel. I think that again lends itself to the question of independence. The next section is under Section 6, Inspection Procedures, subsection 5, under monitoring. Let's see. Under monitoring, near the middle there it says, the COB may not attend internal affairs interviews with police department employees. I would propose scratching that and allowing them to at least sit in on those interviews. The rest of this bill does prescribe that they may not in any way interfere. It in fact says that they cannot ask questions. They can only submit questions to IAD. So having them in the room, I think, is the very least in order to be able to get all the information to conduct a thorough interview, a thorough investigation. The next section is Section 8, also under that same main section, subsection 8. There is a line under subsection 8 about completing the IAD investigation and forwarding information. It says within the reasonable time, is what the current language says, the commissioner shall forward the investigative file to the COB. I would propose either scratching within a reasonable time and just say that the commissioner shall forward the investigative file to COB, or to be more specific. But just language such as reasonable time is pretty open. Under the next section, COB review, under subsection D, independent inquiry. This specifically outlines how the COB may vote to do an independent inquiry. The current language says, if the COB finds. I'm going to scratch that. So if the COB, by an affirmative vote of a majority of its members, currently the language says by a vote of at least 5 of its members. Now keeping in mind we only have 7 members. 5 of 7 is a super duper majority. So I would propose, like almost everything else in here, that is a majority vote of its members, and that would be 4, unlike some other areas in here that say a majority of its members present at a meeting where there is a quorum, which could be 3. So it would be at least 4 members to get an inquiry. And the current language outlines that in order to do an independent inquiry, it would basically have to find that IID failed to do something. It says that IID failed to investigate a complaint, failed to properly notify or involve the COB pursuant to its ordinance, failed to follow protocols, its own protocols, in conducting the investigation, or failed to provide the COB with findings and information as required by this ordinance. So the threshold is very high. You must basically find that IID has broken its own rules. I would argue that you can simply, under a majority vote, they can choose to do an independent inquiry if by majority vote they disagree with IID findings and recommendations. If the threshold is to say that basically they've broken the rules of the law, that is a very high threshold to conduct an independent inquiry. The next section, E, this is also language taken from other civilian oversight boards, adds another possibility that the COB, by an affirmative vote of the majority of its members, may decide to conduct an independent inquiry simultaneously with the IID investigation from complaint it deems appropriate. Under the existing way, the way it would happen was that if something occurs, perhaps a violation of police procedure or something, someone can make a complaint, IID conducts its investigation, which may last however it lasts, and then only upon the completion of its investigation, and then supplying within the time frame allotted in this ordinance, supplying the information to the Civilian Oversight Board, then it would vote to conduct an independent inquiry. So the translation is that between the point of when the offense occurred and when the COB would start an independent inquiry is months. And as we know that, witnesses' memories aren't as good months later, evidence isn't there, the strength of that investigation is weaker months after the occurrence. So I think in order for it to actually be a meaningful investigation, they should have the authority to be able to do that at the same time as the IID investigation. Again, keeping into account all the different safeguards in here that clearly say that they cannot in any way interfere with the IID investigation, they cannot participate with the IID investigation, so it would not in any way prevent the police from doing what they currently do. Also on that page, under subsection, actually on the next section 11, subsection 11, COB findings and recommendation, the COB shall determine by a majority votes of his members, and this is at a meeting where a quorum is present and based on the preponderance of evidence, is the current language, final findings and recommendations. So first, at a meeting where there is a quorum present, if there's a body of 7, quorum would be 4, that would be 3 as a majority. By scratching that, you actually raise it to 4. So a majority of its members would be 4 instead of 3. And then the other section, based on a preponderance of evidence, that's open to interpretation here. And I think some people could argue, and maybe the police union would come back and argue that there was not a preponderance of evidence, and in some way argue that the recommendations and findings are not valid. So I would scratch all of that. And I think the last, oh, nope, sorry. Getting into the, under the same section, subsection 14, officer-involved shootings, subsection B. current language says, the commissioner shall provide the COB with copies of IAD findings, recommendations, and the investigative file only after the Force Investigative Unit and the Deadly Force Review Board have completed their analysis and provided their final reports to the commissioner. I don't think the word only is needed, and it may only act to add some legal confusion. You can simply say that he shall provide that information after the Force Investigative Unit has completed theirs. So I think adding only just adds some confusion, unnecessary confusion. Also, let's see, under Section 8, confidentiality, subsection 5, violation. This clarifies a few things or just strengthens that section a bit for if in any way any member, staff, employee, volunteer in any way breaks the confidentiality of these investigations and releases any information. It spells that out a little bit further. Instead of saying just anyone in the COB, it clarifies a member, a staff, employee, a volunteer, anyone who might in any way come in contact with any sensitive information. It includes them in the penalty for this. That last section, though, says if any COB member or staff suspects that any COB member has violated the law, including suspected violations of the Sunshine Law, the matter shall be referred to the police department for investigation. One, I think it's kind of understood if somebody believes that there is a violation of the law that they can either report it to the police department or some investigative unit, maybe even the circuit attorney's office. But I think by including that, I think it may act to intimidate some employees, volunteers, members, that the police are constantly watching them while they're supposed to be watching the police. So I don't think that's necessary. Confidentiality questions. Again, dealing with the issue of independence. The first line of Section 7, confidentiality questions, says that if the COB members have any questions pertaining to the Sunshine Law or confidentiality, the COB must contact the City Council's office and must act according to the legal opinion provided by the City Council's office. So the City Councilor, as you know, is a mayoral appointee, and going back to the section earlier, if the COB is elected to get their own outside counsel, I think it's they can rely upon the information of their own counsel, including, just keep in mind that now 2 members are lawyers. So again, I don't think, and we've seen in the past some city councilor opinions being a little politicized. And the last, at the end of that same section 7, again, it says about the city council's office. So again, if they have opted to get their own outside counsel, to be more independent, I think they should have that ability to rely upon their outside counsel's opinion. And that is a walkthrough of proposed changes. Takes into account a lot of input from both law enforcement, community members, activists, other aldermen. And so we have an opportunity to take some of those changes, all of those changes, amend the bill on a case-by-case basis with several amendments, adopt the full committee substitute. As the chairman has said, is that we won't be acting on this today, but this, I think, is probably the most thorough conversation we've had about the bill. And so I welcome any questions or concerns. I know that a few things have come up that were not included in the bill. For instance, the further tweaking of the nomination process and the membership. I know there's Alderman from the 27th had a concern about whether we can actually let this body receive complaints from officers, specifically minority officers that may have concerns about how they've been treated or disciplined as compared to some of their white peers. So that's a possibility to add some of that language in there of the oversight and authority of this commission. So with that, I'm open to questions.
Okay, we have, I did not see Alderman Moore there. He still had a question on Board Bill 208.
Which is what we're on, yes.
So we'll give him the opportunity. He's not a member of the committee, but we'll give him an opportunity, then we'll go back through the committee list. Alderman Moore?
Yes, I had 47 questions, but I'll just ask one.
Appreciate it.
In the issue of fairness, I want to know how or will this group, this committee, this board be able to, or will they be able to help us with visibility and more police patrol? Because this is how this crime is created, with lack of visibility. So the people in the Fourth Ward wants to know why there is no visibility. So while we are organizing this board, can we put a provision in there talking about more visibility, more patrol, not just in South City and downtown? When the chief make those statements about visibility and more patrol, and how we, the 160 officers and then the highway patrol coming into St. Louis, we don't have that. So will I, as an alderman, be able to stand before this board and ask this board about the concerns of unfairness, because we don't have the proper amount of police officers in our community patrolling, and the visibility offers the criminals the opportunity to create more crime because they don't see the officers that we need in this community. So I noticed that when something happens downtown, the chief makes a statement about more police visibility and more patrol, but not in my community. So is there a way we can put the provision in there, or are we allowed to step forward, or are we going to leave it strictly up to the chief?
The proposed Civilian Oversight Board does have the authority to review policy and procedures of the police department, but like anything the COB does, all it can do at the end of the day is make a recommendation to the chief. If you are looking for an entity that has the actual authority to hold the chief directly accountable, that would be either this committee, Public Safety Committee, or the mayor directly. But this board can only make recommendations. But to answer your question, it can make recommendation on police procedures, the number of police per district. If the COB was in effect now or last year, it could have made a recommendation about the chief's decision to redistrict and how those officers would be assigned. But it's only a recommendation.
Okay. All right, we're still discussing Board Bill 208, and we're just generally discussing any thoughts and ideas related to changes. So we're not confused. We're not discussing committee substitute. We're discussing Board Bill 208 and just generally discussing ideas for changes.
Yes.
Are there any questions in terms of some of the ideas that Alderwoman Cruzen now has you have something? She was not on the committee. We didn't give her a chance earlier. Alderwoman Cruzen.
Some folks have suggested that the individuals serving on the Civilian Oversight Board should vetted in the same way.
Excuse me, Mr. Chairman.
They can't hear you. Can you get to her?
28 to come to the mic?
Thank you. Some folks have suggested that the members of the Civilian Oversight Board should also have to be vetted in the same way that a police officer is vetted, that they should not have a criminal background that might involve a police officer. I know that the bill does say they can't have a felony conviction, that they should be held to the same sort of standards that a police officer is held to get hired. So that's one question. The second question is, would you anticipate that the employees of the Civilian Review Board, and I know now I believe I'm talking about one of the suggestions you have for the committee substitute, would you suggest that those employees would be civil service, or who would they actually work for, and what would the process be for that? So I'll start with just those two.
Sure. So the first question about vetting our additional requirements on COB members. I would say that I think the requirements that we have, and especially the terms, so meaning that every 48 months a member would either be replaced or reappointed, is more than many public safety employees have to do, more than many people who work in City Hall now do, and many boards are currently appointed that way. So I don't think they need any special requirements that way. I do believe that there is a section here that specifically says that they need to go through the what is it called? The Citizens Police Academy. So they would have to go through that. So I think
go through that before they serve, or do they have to go through that just within their first year of service?
Right, they have to go through that after they're appointed. So they have to at least become familiar with police procedures. So I don't think that's necessarily needed to add a requirement that they would have to go through the police academy or somehow receive gun training. I think police.
That really was that wasn't what I meant to imply. If I did imply that, I apologize. I was really thinking about significant misdemeanors and that sort of thing, maybe fingerprint checks or that kind of thing.
I think the balance, the check and balance we have for that is the confirmation process. So unlike most appointees, this specific body would have a confirmation process here at the Board of Aldermen, where about every member would be able to ask, members of the Public Safety Committee would be able to ask questions. People will be able to make public comment on the person. I'm sure the police union would be paying close attention and will have comments on anyone. And that is an additional requirement that is not required for most committees or boards.
You anticipate that all the appointees would come before the Public Safety Committee? I might have missed that. Is that called for in the bill, or is it just confirmation by the Board of Aldermen?
It is confirmation by the Board of Aldermen, but I do believe, and the chair could probably speak to this.
There is a.
In the, let's see, let me find a section about the.
There is a provision for them coming forward.
Here we go, confirmation.
Okay. Okay, so that's the way you anticipate that it would work, that everybody would come before the Public Safety Committee before the Board of Aldermen voted on them. Okay.
Here we go. It's actually in page 8, line 8. Confirmation within 90 days of the mayor's nomination, the Public Safety Committee of the Board of Aldermen shall hold public hearings concerning the nominees, and the Board of Aldermen shall vote on whether to confirm the nominees. So again, that's a step that I can't imagine. I don't think of another body that another board that we have that requirement for.
Yeah,
it's actually a good thing. I think we should do that more often.
I think it's at the option.
It's the option.
Right. Okay. And so would the employees of the COB be civil service? Or?
They will be employees of the Public Safety Department. Okay. So this Board Bill 208 is written, says that the COB will be under the Department of Public Safety.
Right.
And so therefore employees
like any other Department of Public Safety employee. Okay. I am one of the sponsors on Board Bill 208 that's before us, and the committee substitute, the proposed committee substitute that was circulated yesterday, and is printed here today. I don't know if you spoke with other co-sponsors about that proposed committee substitute or not, but I'd be interested in that process. I mean, I feel a bit like, I was on the original bill, and now there's a committee substitute here on the desk that also has my name on it, but I wasn't consulted about that.
Mm-hmm. So two things is, yes, there were conversations between some aldermen, not all, and so now is the opportunity. So today is the first day there was all these different suggestions were put into one form.
Well, I got it yesterday.
Okay, so you got it yesterday.
Mailed out yesterday.
So it's an opportunity for now everybody to see all the recommendations. We even highlighted all the changes, which is
Yeah,
probably
I saw
something we
that.
should do.
That was helpful.
We should probably do that more often, I think, too, down here, is to clearly highlight all the additions, subtractions, changes, additional languages. And I think over the next few days and week, everybody will have an opportunity to talk and meet. But I think the first step was to get it all on paper and let everybody kind of see what we're talking about specifically. Because there's a lot of ideas floating around. People have kind of vague ideas about, I kind of want to see this tightened up, or I want to see this loosened up. But in order for us to have a constructive conversation, I think it all needs to be written down. So this is step one.
Yeah, I don't object to it being written down. I just object to it being published to the media and everybody else with all the co-sponsor names on it when the co-sponsors had not been consulted, or at least some of the co-sponsors had not been consulted about it.
Okay. So the clerk, in accordance with our rules, in order for us to discuss it as a board, relayed it to all the committee members and aldermen yesterday. I'm not aware that he sent it
somehow because
yeah, I'm not aware if he sent it. I didn't send it directly to the media, and I don't know if other aldermen did. But in order for us to discuss it in the public body, it has to be submitted some way. So it has to be shared.
No, I understand that.
And again, as the chairman mentioned, is that we haven't taken this up yet.
Consulted before, you know, if some people were, then I mean, it seems to me that all the co-sponsors, it would have been nice to be consulted about that. So.
Okay, we'll chat today.
Thank you. Questions from members of the committee on these thoughts and ideas of changes. Alderman Schmidt. Going down the line.
Alderman, you gave us a lot to chew on. I'll try to go as quickly as I can through some of these. So the first one that you talked about in terms of saying that the complaints by civilians should be against law enforcement officers, I think that's just sort of like grammatical and so forth, and you were talking about that on, it shows up, I know we may not be doing this as your substitute, but it shows up in a couple pages. On the independent inquiry, which just happens to show up on page 4 of your suggested amendments, talks about the COB may interview complainants, witnesses, and employees of the police department. So the issue on that might become that whole Garrity rule thing in terms of the fact that police officers are required under oath to to indicate, well, to testify fully, even though normally that might put them in jeopardy of violating their protection against self-incrimination. So I wonder about that part on the employees. Also on that, on line 13, it happens to show up, it says there, citizen complaints, but throughout the document, first of all, if you're not a citizen, you still have a right to complain against the police department. And so elsewhere in the document, it talks about civilian complaints against law enforcement officers. So I'm assuming that that's what you mean, because a citizen has a very clear term of art. It means somebody, obviously, who's naturalized or was born in the country or takes a test and becomes a citizen. So you don't have to be a citizen to have a run-in with the police department, nor do you have to be a citizen to make a complaint. So I just raised that there. In section 3, you talked about, and you may find this amazing that I'm going to say this to you, that at least 2 of the members of the COB shall be attorneys licensed in the state of Missouri and in good standing with the Missouri Bar Association. So, lawyers all have different areas of practice and whatnot. Quite frankly, I think it's more important that the Civilian Oversight Board have somebody. It normally would be the city councilor, who is in fact charged with that obligation to interpret the law and kind of give advice with regard to the law. I'm sort of concerned about, and we discussed this earlier, having a bankruptcy attorney or somebody who practices in civil practice or something like that, or even maybe having somebody in criminal practice who either has always spent their entire career as a prosecutor or as a public defender. And then people on the board sort of listening to what they're saying as opposed to, you know, how it is really impacted in terms of municipal law and so forth. So I understand that we don't necessarily want to have police officers on the board. That idea of having somebody, you know, with a criminal justice background, or, you know, I think it might even be helpful to have somebody from UMSL or somebody like that. Not that you could specifically say that, but it would be helpful perhaps to have them more than an attorney who really doesn't have any knowledge about how these civilian oversight boards work. It's just, and then there's a provision that talks about at the first meeting the COB shall elect a chairman and a secretary. I thought that we were pretty much leaving to the Civilian Oversight Board that they shall now, not may, but shall devise their own rules and procedures, and that they're going to follow the National Association for Civilian Oversight of Law Enforcement Code of Ethics. So I'm not real sure why we're specifically saying that they shall select a chairman and secretary. I don't know why that's so special. You know, it might be included in the other stuff. I'm just reacting to the stuff that you mentioned.
If I can comment on a couple of these things before we...
I didn't get to comment on yours, so I'm just going to kind of quickly...
Oh, did you want to answer some of those?
Yeah, and it's up to you. I'm just trying to kind of react. Like, I heard a whole bunch of stuff quickly, and I'm going to kind of go quickly through it. The registered voter, I think, is a great idea. The 25, I don't know if there's any magic about that. Aldermen have to be 25 years old, so I don't know. I can tell you that I am not familiar with the National Association for Civilian Oversight of Law Enforcement Code of Ethics. I assume that's good. I don't know if other groups use that one or not. So there may be a lot of things that are covered in here that hopefully would not be in opposition to what that code of ethics is. So just, I mean, I don't know what it says, so it would be helpful to deal with that. And you are absolutely correct on the portion about the COB districts, which finds its place on page 7 of where it listed under your committee substitute. The only thing that I would add is that we always change the location. When we do redistricting, it's sometimes we change the entire location. And I think that's what you're getting at, as opposed to maybe there's a little bit of a change of location and somehow that would then somehow change how we go through and identify these districts. So I don't know how that impacts that. I think it's sort of how we talk about what does location mean. Then you have nominations. So here's what I think the earlier board bill might have been trying to get at in terms of the mayor paying attention to the nominations but being in a position of making nominations. And it's a difficult balance. I agree. But you identified alderman situations. I think you even mentioned in Baltimore where there are some empty seats. And so the concern I have is that we may not be as diligent as we ought to be, and so we may not send nominations up to the mayor, and so then what happens? Or maybe the nominations appear to be great, but part of what we say here is that they should be fair and objective nominees, and the mayor looks at those and for some reason believes that they aren't fair and objective. So I guess my concern is how we make that language fit what you're saying so that the mayor can't just sort of carte blanche do what he wants to do, but at the same time not leave it up to a situation where we're not sending nominations in there, so therefore the mayor really can't act and we have empty seats. I don't know what that answer is fully, but I think that's what we're trying to reach. Where some of the others in terms of at midnight that they end, I think is fine. You know, I had some issues initially, but I think you have to have the staggered terms. It seems like some people will only be able to serve initially the 6 years and others will be able to serve 8. That may be a punishment having to serve the 8, I don't know, but in any event. So the meat of this is reflected on page 10. So the subpoenas and so forth. I think that becomes the crux of what is going on here. So as I understand it, subpoena power has to somehow be granted to the state or elsewhere. And so previously in the legislation, I think that our chair did, we were sort of going through the subpoena power, I guess, of the police commission. Okay. But the police commission in some fashion, because they had control over this board, the oversight board, somehow that devolved upon the oversight board. So it seems to me that what you're attempting to do here is to say the Board of Aldermen has subpoena power and we are somehow delegating that to a board over which we don't have any control, essentially.
No, it does not mention that the Board of Aldermen is giving its subpoena power.
Whose subpoena power are we giving to it?
So the addition of that was based upon opinion offered by the Attorney General's office.
But whose subpoena power is it?
So the Attorney General's office sent us over an opinion that stated that under their interpretation of the Missouri Constitution and the City Charter is that if the Missouri legislature has not specifically, as a charter city, we have all rights and responsibilities given to us under the state charter, unless, under the state constitution, unless the state legislature has specifically in some way said that we do not. And
we had this discussion in a previous area of law, yes.
Right. And so based upon that, they concluded that the Board of Aldermen does have the authority, taking into account the state statute which specifically authorized the creations of civilian review boards, specifically for the point of investigation and inquiry, that we would have the authority to create that body with subpoena power. Now,
so that is a delegation of our subpoena power, is what you're saying. That's what I was getting at.
Okay, and so the city councilor, the mayor's city councilor, has disagreed, and so what we propose is putting it in there, and we have a severability clause. If the Attorney General believes we have the authority, but there are some that don't, if this is challenged, that part, under the severability clause, that would be struck out if a court says that they side with the city council over the Attorney General, and the rest would stand. But putting it in there as its lone provision will give us a final answer.
Okay, well, so there may be some means, like if the Board of Aldermen delegates to committees, it controls that subpoena power. And so there may be a way for us, if we had control over the operations of the Civilian Oversight Board, to delegate our authority, our subpoena power.
So, Alderman, I would argue this.
I'll just finish up here and
the
say
question,
that there are two ways of approaching this, Alderman. One is to throw it at the wall and see if it sticks and get a whole bunch of people excited about the opportunity, and then we go through this tortuous process of not having a very effective civilian oversight board, maybe even having some injunctive relief, or seeing if we can do what we know that we can do, and then if we need this power to develop it that way. I'll just say that. And I understand what you're trying to do. So then on D on that.
Offer some input on that? So I would just say that the question for us first is to decide as a body if we wanted to have subpoena power. Then there's a lot of different ways you can go about that. You can do that in this way of adding through an ordinance. You can put it to the people to have a charter change.
Right.
But the point is do we want it to have subpoena power? And there are some who flatly do not want it to have subpoena power. And so whether it is legal under the charter or the Constitution or not, they would oppose the inclusion of this. And they would also equally oppose a separate bill to put the question to the voters as a charter change. So I think each of us as individuals have to decide if we want this body to have subpoena power or not and vote accordingly.
Right, and a timing issue about when we do that. Right. So then under subsection D, it says all witness testimony shall be recorded. So again, this gets to the Garrity issue in terms of recording all this, because at some point then the Civilian Oversight Board had, within this bill, it indicates that those members have a right to everything, all the records and documents and everything else. And so I just urge us to continue to keep that in the back of our head. We may think that we want something otherwise, but there's a chilling effect that occurs, and if somebody's under an obligation to testify fully, and yet they also have a constitutionally guaranteed right against self-incrimination, we've got an issue. So I just raised
I would point out, though, that it does in the bill also say that they do not have the authority to investigate or to interview an officer accused of the
I understand, but if they get at the same thing through a back door, it could potentially. I think what we're trying to do is get something that works, get this working so that the public can have greater confidence that there is a true process here that's working as opposed to not. That's all I'm trying to do. I'm not saying I'm against subpoena power. I'm just this other part that talks about false statements, reports, and so forth, and on conviction. So frequently when we do these, Alderman, somehow there's an administrative process that's put into place or something that gives direction in terms of how that is identified. And I'll throw this out there. God, I haven't thought about this forever. But it's almost like a star chamber kind of thing, where you come before this group and you're testifying and so forth, and the argument may be made that, you know, the commissioner who's the chief of police and the mayor are the only people who can ultimately decide your fate. But through this process, if the COB decides that you've somehow lied or something, all of a sudden you've got $500 and 6 months in jail and all these other kind of things. So sometimes there's a due process procedure in terms of, you know, does this go through an administrative hearing type thing where, you know, somebody makes a decision that in fact you said this and in fact this is what happened, and then you can appeal it to court, those kind of things, so that if and when, and I suspect when, if we're not careful, if we have too many, you know, if we Christmas tree this too much, when this goes to court, the judges say, okay, yes, but it's not the same group that's deciding that they lied. It's going through a due process procedure to, in fact, show that occurred. So then also you talk about the recommendations needing to be submitted to the Commissioner, Director of Public Safety, and members of the Public Safety Committee that's of the Board of Aldermen, I assume.
Right.
So that might be included there because it didn't say of the Board of Aldermen. It's just a small thing. So then you talk about reports from the Director of Public Safety. I mean, it says that the Director of Public Safety shall provide information. What happens if the Director of Public Safety doesn't? I'm not suggesting that we can do anything about it. I'm just saying that shall usually suggests that there's something there. On the records, I know that you indicated taking out to the extent permitted by law, because that's understood. Let me argue that it's really not understood. So that if we're saying they have access to and the ability to obtain copies of all records, and we've got that Garrity issue and perhaps others that I'm not familiar with because I don't know all of these things, and somebody who is a lawyer practicing in this area might know, that saying to the extent permitted by law is a safe harbor, what we call almost sort of like a safe harbor. So it sort of suggests to a judge that there's some sort of break on this, that we're going to say, hey, yes, they have a right to all of these, but we do recognize that there are some laws that may intervene to suggest that they don't.
And if I can say one thing about that, I think including that language to the extent permitted by law, and then also including the later language that the board must rely upon the city councilor for all legal opinions.
I haven't gotten to that part. I understand.
I think those two things together are problematic.
And they might be. Yeah, they might be. But I don't think in and of itself, without that second part that you're talking about, that it is. I think that in fact it could be a healthy thing for a court to see. It just strikes me that it might be. In terms of the meetings, this is interesting, and I looked this up because I remembered the situation but didn't remember the gentleman's name. So my reference is going to be to Marshawn Lynch, who kept saying, I'm just here so I don't get fined. So what we're saying is that the COB has to meet at least once a month. I'm assuming that they're going to have these rules that we expect them to do, and what you're trying to do is make sure that they don't just meet once a year or something and go, like they're finished. But I'm just thinking of that sort of...
Well, it would also provide the public an opportunity at least once a month.
I understand, but they could come in and say, we're here meeting, adjourned. I'm sorry. I thought the thing on the rules is good to say that they shall adopt rules. I think that's helpful. Also that the rules and procedures definitely are available. Some years ago, I went over to the court in Belleville and asked them for their rules of court, and they said there were no written rules. So it's, I'm sure that's not the case anymore, but having those rules in writing are helpful. I think you had in section 5, it shows up on page 16. I think it's helpful to have the staff and so forth. There is a cost associated with that. And what you're saying is that the COB could elect to use some of the existing staff, is what you're saying, but they're not required to? Or you're saying that they have to have this executive director and...
Right. So the line 17 would say that it does have to have an executive director and investigators. Now, all that's going to be subject to the budget.
Yeah.
And the public safety director ultimately controls that. So whether or not you can afford to have 15 investigators or one will be decided by the budget. So that still gives the public safety director and therefore the mayor and the budget director a lot of authority over how big and the capabilities of the office.
On page 18, legal advice, I would argue that whether or not they're going to pay attention to the city councilor's office, I think rather than having these attorneys that are members of the board, I think we should be very clear to direct them that they shall obtain legal advice from the city councilor. You may want to put language in here that talks about their ability to get independent outside legal counsel, and obviously there's an expense to that as well, and how that might happen. I think that it's more than one or two words probably, but at the outset, I think at a bare minimum that they should definitely know what the city councilor's position is on that, and then sort of go from there as opposed to may. I just think that's more important than having members who are attorneys who may not know anything about municipal law or anything else. Just my opinion.
So one thing I would be open to, so in no way by having the requirement that at least 2 members would be attorneys would mean that they would rely upon their own members for sole legal advice. And I'd be open to including language that specifically bars that. But I think it is of value to have people with understanding of the law be on the board. But yeah, I agree that they should not, sometimes lawyers are their own worst clients, just like doctors, so you don't want them being the sole source of legal information. I agree with that.
Right. This shows up on page 20. And originally it said that COB may not attend IAD's interviews with police department employees. Again, I think that rolls into that Garrity issue. I just raised that, and I'm not clear enough on how all of that happens. But if the records are available, and if they have the ability to be there, then I think that these are issues that will come up under that. I just think that they will.
So what I would say, though, is that by including that specific language, that bars the COB from ever attending. And keep in mind, the other language says that they can't ask questions, they can't participate in an interview in any way. But by barring them from even being able to attend any interview of any police department employee, not just the officer accused, but anybody else, I think that is kind of overreaching.
I don't know. I don't know what the
state
for instance,
of the even an interview with a secretary.
I don't know what the state of the law is on that. I think it's an issue. I know enough to bookmark that and say that it's potentially an issue. Before we said that they couldn't, and I think again we're on that finely balanced watch kind of thing that we talked about in terms of no one being totally satisfied with it, and yet having that balance. And part of it was on that some of the legal tipping issues in terms of what will have this before a court that endangers it more than anything else. I don't know what that is totally. I'm just.
But like for instance, in that case, though, I would say that if it is, if a certain interview is already illegal under Garrity, then it is already illegal, and so it isn't required then to include specific language that would extend beyond that.
I think they're required to go before IAD and testify. That's the reason why you have the issue with the self-incrimination aspects coming up. I'm not sure that it expands to anybody else than that specific group. So if it does, that's fine, but I'm not sure about that.
And if it does, then that is the current law, so it wouldn't need us to restate it.
On page 22, it said before, within a reasonable time, the commissioner shall forward the investigative file. And you said by taking that out, it made it less open, I guess. I think that it makes it even more open because courts are used to looking at within a reasonable time. Reasonableness changes from time to time, but they interpret that often. Without that in there, they may apply a reasonableness standard anyway. I don't know. I guess if you really wanted to be more precise, I guess you could say the period of time in which the commissioner would.
Right, I mentioned that too.
Yeah. All right. And I'm sorry, I'm trying to go as quickly as I can. Page 23. So in the independent inquiry, I think that's probably a good idea. It strikes me just on first hearing that you'd have to have 4 as opposed to 3. So it's a majority of the members and not a majority of the quorum. The thing that I see here is that if they decide that they disagree with the IAD's findings and recommendations, then they can ask to do an investigation. Whereas before it was that, that IAD failed to investigate it or didn't properly notify or they failed to follow their protocols and so forth. So essentially, it's like a Mack truck can run through this. So anytime 4 of the members say, well, we disagree with the findings and recommendations, and so now we're going to do a full-blown investigation. That may be what's desired or even desirable. I don't know. I haven't made a value judgment on that yet, but it very clearly changes that entire dynamic about, earlier we were saying that there were very defined times when COB would, in fact, do a full-blown investigation. This opens it up totally.
And I would say, to a point earlier, that we don't want to create something that gives people a false sense. And so by creating a civilian oversight board, people would assume that it has the authority to investigate complaints. I think the existing language limits it to only being able to do an independent inquiry if clear protocols, rules were broken by IAD, which I don't think is, my opinion, is not that common. I think what is more common is that people may disagree with IAD's findings, but whether they broke their procedures or not, and again, they get to decide what their procedures are. I think that's a pretty high bar, and that would result in far less independent inquiries.
It would. I mean, it clearly would. And so there may be some other ground, but it seems like one is quite restricted and the other one is quite open. So, I mean, maybe it would be something like IAD failed to properly investigate or fully investigate a complaint as opposed to just disagreeing with an IAD's finding. That's more of a personal gut type of reaction as opposed to some sort of standard of when you investigate. But anyway, I'm not making a value judgment. I'm just saying it's totally different than a more limited sort of, might require 15 investigators as opposed to one investigator or whatever. Because
and under the current, it would almost, it would require a determination that the rules or the law was broken by IAD. And again, taking into account the later part, which I'm sure you'll get to, if the determination of whether the laws were broken can only be made by the city councilor, and the COB must follow that, again, those things taken together.
I understand. So I offered that maybe it would be that IAD failed to properly or fully investigate. Somehow they would have to look at that and say, not just that they disagreed with the findings, but that somehow or another they decide that based on, what IAD is supposed to do, that in fact they didn't properly investigate it or whatever, that somehow they would connect it to this particular complaint as opposed to just a visceral sense that they didn't like the outcome. Okay. So then under E, this is an added one, that they may decide to conduct an independent inquiry simultaneously with IAD. So the prior kind of setup was to give IAD a chance to say, okay, we understand that this is what you're required to do. You've got all these abilities and so forth, but if we have a sense that you didn't follow your rules, maybe we add the thing about that you didn't properly investigate it or fully investigate it, that you didn't notify and involve the COB and so forth, that we're going to review it. Now, what this says is that there could be these parallel investigations on each and every situation that arises, and so that's a totally different way of looking at it.
It adds additional authority and power to the board. Keeping in mind that at the end of the day, all they can do is make a recommendation. But also take into account that an investigation started months after the occurrence, with less ability to track down witnesses, less ability to get fresh testimony. It almost always ensures that the COB investigation may not be given the same information or have the same access to valuable information and witnesses that the IAD investigation has, especially if you consider the timetable. If you lay it all out, IAD can take as long as, I think it says 90 to to 120 days, but it can take a long time to do its investigation, and then the determination has to be handed over to the chief. The chief has to make his determination, so it could be months after the incident before COB could even start an investigation without that. And again, they wouldn't have to do that in every case, but at least we'll give them the authority to vote whether we should start our independent investigation early or have to wait.
Yeah, and the only thing is it might create some additional confusion by having two simultaneous, unless they somehow cooperated together to do these things. And again, I don't have enough knowledge to know, how the whole thing goes with the police officer herself or himself. But
and again, I'll just say that if people have an assumption of what a civilian oversight board is and would do, and I think most people assume that after a case happens of possible police misconduct, that when they make a complaint that CIB can investigate. But if we're saying that they can't even start an investigation for several months till afterwards, I think that's kind of a false representation. So I'm open to changes to that and tweaking that.
There might be some consideration, and I don't necessarily want to be writing this, but there might be some consideration of what the standards might be for that.
So that particular...
so if there's a police-involved shooting or something, maybe that is, and there's obviously now we're going to have the circuit attorney's office, and sometimes the United States is involved, and and then IAD and Civilian Oversight Board. There might need to be something that identifies when that's going to happen, because pretty soon you're going to have this office with the 15 investigators and investigating each and every situation that arises, and then we don't really focus in on what we're trying to get at. I don't know. It just seems like IAD and COB could come up with totally different answers, I suppose.
Yes, they could. And that might be desired by some folks. But as you look at community and civilian oversight boards throughout the country, what you find is that over 90 to 95% of the time they agree with IAD. But it does give an added sense of independence, and actually it could even strengthen people's faith in the IAD investigation when there was another set of eyes looking at it.
It's difficult for them to agree with IAD if we don't even know what the IAD decision is yet, though.
So in that case, you're assuming that the COB investigation would be completed in advance of the IAD investigation?
No, simultaneously, so it might happen at the same time. Yeah, so they both come up with a decision, but we really haven't given IAD a chance. I just raised that, and it's a different philosophy, and again, that balancing act of trying to make sure, it's like when we do administrative hearings and so forth and exhaustion of remedies, we sort of allow the process to happen as opposed to, saying everybody has to go to circuit court or whatever. We let, each and every one of these sort of lower level processes happen and go up. So then, COB can say, well, let's look at this. Okay, did they interview these people? Did they find this evidence? Did they take a look at this? As opposed to COB having to do a full-blown investigation every time. I just raised that. Let's see. So then it talks about the findings and recommendations. So you're saying 4 of 7, which is better than 3 of 7. And then preponderance of the evidence does have a meaning, I think. It means that we're not looking for beyond all reasonable doubt or some other standard. We're looking for preponderance of the evidence. So more likely than not. But somehow tying it into the evidence, I think it's helpful to have that. On page 25, the investigative file coming over to the COB after the Force Investigative Unit. So my suspicion is the reason why it said only after is because if it just says after, that means it does come after, but it also could come before or during or whatever. But when it says only, it's very specific that it's only after. So it does have, it does have a meaning.
As opposed to investigative file after?
Right. So it has...
I don't think anybody can confuse
the investigative
before.
file has to come after the Force Investigative Unit, but if it doesn't say only, then it could come before as well. Or during, but it does have to come after. So when it says only means only.
But it says after.
Only after. So I just wanted to point out that it does appear that it could have meaning, that it can only happen only after.
Okay.
So then, in terms of the violations, you talked about that on 28 and 29. And I'm not suggesting that we do this, but earlier when we talked about misstatements or I guess essentially under oath not being truthful, we put on a $500 fine and 6 months in jail.
Mm-hmm.
But for this, all we say is that they'll be disqualified from serving on the COB and that we're going to send them to law enforcement authorities. But it doesn't really say anything beyond that. I'm not suggesting that you want to. I'm not sure how we should be treating the others, but it's at least worthy of consideration of balancing those in a parallel way, that we don't want either one of them to happen. And what you said in terms of the ethics, that one national standard, which I don't remember anymore, like NCOL or something like that, that may cover it. I don't know. But you're just trying to make sure that nobody does that. In terms of the confidentiality questions, I think that they should have to consult the city counselor's office. My tendency is to agree with you that they, whether they must act in accordance with it. But I think at a minimum they should be required to get that opinion, and that and that's it. Thanks.
No problem.
Thank you all.
Okay, Alderman Boyd, did you have any questions or comments?
Yes, thank you, Mr. Chairman. That was pretty detailed, Alderman, from the 20th. I have several questions. Are you of the opinion that whoever the alderman recommends for an appointment shall be appointed by the mayor?
I think that the nomination procedure implies that the mayor will choose from those that are nominated by the alderman. But then that additional sentence then says that he actually does not have to appoint based upon those nominees. So I think a middle ground might be that the alderman can supply a certain number of names and that the mayor must choose from that list. But it doesn't, to me, make much sense to have a nomination procedure when the mayor doesn't have to follow it.
Well, let's role play this. So in the cluster that I might be in, if I nominated someone, and I'm the only alderman that nominated someone, and the mayor doesn't like that person, or you have the opinion that he has no choice but to nominate that person to the Board of Aldermen?
If you are the only person of that cluster to nominate, so if there's one available name, then yes, they would have to choose among that one available name. But I think that's the point of the nomination procedure. Now, that is also assumes under your hypothetical situation that the other 3 aldermen would not nominate a name or would not have someone that they would want on there, which I don't think is likely.
Okay. It is my hope and desire that if the committee and the board and the citizens and all the stakeholders want a civilian review oversight board, that we would create this in a way that it doesn't create unintentional adversaries and animosity amongst different groups of people. I wouldn't want to pit the Board of Aldermen against the executive branch, no matter who the mayor may be. I would be a little concerned about that because I reflect upon if it was me. I think sometimes we put personalities ahead of policy, and I think that if I am mayor, I have veto power, and I have veto power for a reason, that I may disagree with the proposed legislation based on a set of values. And I think as a mayor, that's the mayor's right across the country. So I would suggest that it would be okay if there's no other nominee, or if for any reason that the mayor disagrees with the nominations, that it can be open to somebody that whoever the mayor is in line with the philosophical views of the mayor. Now, I know that doesn't sound good, because it seems like what we want to do is, you know, kind of be very autonomous to the point where maybe I'm overreacting, overthinking that this board would almost be able to do what they want to do, and I'm concerned about an overreach of a power being given to an entity that sounds like it's an outside entity, but it's really an inside entity, because the staff people would be city employees. So it caused, for me, I'm kind of confused at that relationship, you know, throughout this particular bill.
I mean, about that point before you move on, is that first, I would say that to remind you that even after the mayor nominates the person, they still have to come to the board and be approved. And so in the current language, that's how it is. That's the current language. So I would ask you then, would you support there be no nomination procedure and that they would just be appointed by the mayor? Because that seemed to make more sense.
Absolutely not.
And it just seems to have kind of conflicting if you have a nomination procedure where it comes to these sub-districts, but then the mayor doesn't have to abide by it. It just seems conflicting to me.
Okay, but I wanted to be appointed by the governor for license collector, and I had a lot of support to be appointed by the governor for license collector, but the governor chose who he wanted to choose, and there was nothing anybody could do about it because that's the governor's right. So the mayor has certain inalienable rights that come with the office, and I'm concerned that if you were mayor, that we would tie your hands in a situation like that.
Well, currently, the mayor has no authority or anything relating to a civilian review board. We are creating that procedure.
Right.
And in the case of license collector, if there was a nomination procedure, then you would assume the governor would abide by it. But in any of those, it seems conflicting to have a nomination procedure and then somebody can completely bypass it. So I would say you either have one or the other.
Do you think that aldermen can recommend people to serve on any board with the city of St. Louis?
Currently? You mean can they recommend? Sure, informally people can make recommendations.
Well, formally and informally. You can put it in writing and make a very formal request that you, the mayor nominates this person for, let's say, Affordable Housing Board, and they have a wealth of experience, but the mayor can choose not to, right?
Sure. Most boards don't go through the trouble of establishing sub-districts and nomination procedures for that, but yeah, outside of that clearly being in the law, it's up to the mayor to appoint for most boards.
Okay. On the staff situation, the alderman from the 27th had a question about fiscal note. Of course, we don't put fiscal notes on bills. However, I am curious as to how this would impact the city's budget, executive director, staff. I mean, what's the minimum amount of staff, maximum amount of staff? What's the general cost to the city to have adequate staff for the board?
So in the current form of the bill and in the proposed changes, the budget is completely left up to the public safety director. And so whether or not this executive director gets paid out of a pot of $100,000 for all the staff or $300,000 for all the staff is really left up to the executive branch to determine what they can do. And so if, for instance, the mayor, the budget director, and the public safety director came back in the next year's budget and put only $25,000 in there for the Civilian Oversight Board, that is what they would have to work with. So it still gives great authority to the mayor's office and the Department of Public Safety.
And how would you feel about that?
I think in order for, and we see this in lots of different offices and departments, in order for departments to actually do their job, they need funding. Now, if they were to come back with our proposed budget, it would be then on the members of the Ways and Means Committee to try to find extra money for it if that was the will of the board. So, we do this a lot. But I think, as I mentioned earlier in my opening testimony, even if you establish a very strong civilian oversight board by ordinance, if the will is not there in the executive branch, there's still lots of ways to kill it and to make it ineffective, and budgeting is one of them.
And certainly that's not what we want to do. Otherwise, it makes all this process very moot and a lot of hard feelings and good ideas wasted. Right. So we certainly want to do that. But I do want to say that there's a department that I would like to create, but I have to be mindful of how it gets funded. And I'm hoping that we keep this in mind as we move through the process about getting funding, because one thing I don't want to do is to create something or help create something that really can't be funded.
Yeah. One thing else, for instance, in the city charter, we should have an Office of Legislative Research. It's in there, but it's not funded.
Well, that's our fault.
It is. Yeah.
That's pretty sad.
Yeah. So
as a Board of Aldermen, we oftentimes, through our leadership, make ourselves last, which is pretty sad. But that's our fault.
Yeah. So there's lots of ways to make it ineffective, and so it is important, as you mentioned, for the legislative branch, the executive branch, to all work together to value this and to try to make it effective.
Okay. If you're performing your duties in your official capacity and you get sued, how are you represented?
If we are indemnified, then the city represents us. In this board bill, it goes specifically to say that these members would not be indemnified.
But it also allows them to seek outside
counsel.
Which means that we would need to put that in the budget just in case they decide to use it as an option, right?
Correct. Like anything else, their capabilities, both as far as doing many investigations at the same time, having adequate staff, being able to seek outside counsel, will all be based upon the budget.
Okay. I'm concerned that if we are represented by the city council's office, that we go outside of those boundaries seeking legal opinions, because at the end of the day, we will be represented by the city council's office unless we want to come out of our own pocket and be represented for whatever somebody decides to sue us for. It appears that you're not interested in the city council's opinion throughout this process, or you tend to kind of minimize it, and I'm not sure we should do that. I think we should magnify it, because if the COB does something or feels real strongly about a position that's just not correct, we're on the hook for it at the end of the day, and we will have to defend ourselves. And our first line of defense is the city council's office. We can certainly disagree with who the city councilor is and their opinion. However, at the end of the day, that's how we're structured and that's how we're set up. And I think we have to truly be mindful of that.
And one is point out that, one, it does specifically say that the board members are not indemnified. Two is I don't have a problem at all with seeking the legal opinion of the city councilor's office. What I do have trouble with is specific language that says that they must follow that opinion. And what that does is put into question any kind of independence. And I, you know, for instance, we wouldn't allow that here, to say that we absolutely have to take the advice of another branch of government.
And what happens when we fail to take the advice of, let's say, the city council's office, and they're right, then we go to court, right? Well, I don't think the Board of Aldermen, if we want to challenge the city council's office, it has the capacity to go to court and challenge the city council's opinion. I've never heard of it being done. It probably has been. I haven't been here but 12 years. But
we can.
No, I'm sure we can. And it brings to mind the firefighters, for example. Certainly they disagreed with the city council's opinion on their pension system, and they took us to court. And the city spent a lot of money defending itself, and the city at the end of the day prevailed, which means that the city council office was pretty much right. I'm not saying they were absolute, but...
Let me correct you on that, Alderman. The city councilor actually was very wrong. So the city councilor's opinion in the very beginning was to say that we can set up a single-tier system. What many of us, including the firefighters, argued is it can't. You have to set up a two-tier system. The city and the Board of Aldermen passed the ordinance. The judge identified errors in the ordinance, and slowly over the course of 3 other bills, we corrected those errors and created a two-year system. So I think it was a case, actually, of the opposite of what you're saying, is that the city councilor was in fact wrong. And if we had not held negotiations based upon a false opinion and worked together to create a two-tier system in the beginning, we would have saved millions of dollars.
And there's merit to what you said, and that I stand corrected, but it also reminds me of how fast we did it and how I cautioned that we shouldn't move so fast, because we hadn't thought it out as well, and we weren't looking at down the road unintended consequences. But I think the point is well taken on both sides. The other concern that I have is when we were doing local control and they came up with the proposed ballot language, somewhere within that ballot language it suggested, well, it said that no elected official will interfere with the duties of the law enforcement, basically. I don't know the exact language, but it was very clear that if we did, we'd be charged with a felony.
Made it a crime, right?
You know, so, which was very eye-opening to me. And then it comes up to interpretation of what does interference look like, and who gets to decide that. So I'm concerned that it goes to the IED piece and kind of adds to what the alderman from the 20th Ward was saying. If they're sitting side by side with IED doing investigations, and not saying I'm opposed to that, what I'm looking at is process and what's right. Is that right? You know, I would like to hear more about that and get some kind of opinion about if we did that, would that be considered interfering with an investigation?
Right. So in both versions, both the current version of 208 and committee substitute with proposed changes, they maintain language that says that the COB may not interfere with IED investigations, and this is even in the version that the mayor added his name to, cannot interfere with IED investigations, cannot, even though they can sit in on interviews of people other than police department employees. They cannot ask questions. They can only submit recommendations for questions to the IED interviewer, and it even spells out, you know, how they can request bathroom breaks or breaks in the interviews. So in no way are they allowed to interfere with IED, and it does spell that out several different places throughout the bill, both versions of the bill. The only change between the committee substitute or the changes that I've mentioned in 208 with regard to that is the original 208 specifically says that the Civilian Oversight Board cannot interview police department employees. That I felt like was a little bit overreaching, because even in their independent investigation, there are some employees that should probably be able to interview in order to have a thorough investigation, although it does preserve the language that says that they specifically cannot interview the accused officer.
I think it would be helpful as a suggestion as far as the membership is to having at least representation of all stakeholders. People who are directly impacted, the citizens, how they're represented, and certainly through automatic nomination, the Board of Aldermen is represented, and we represent our citizenry, but the police association and whoever else, is a stakeholder in this whole process. I think that might be helpful. It's just a suggestion.
I'm sorry, elaborate on that. So you say identify the stakeholders?
Yeah,
you mean like the preamble, like the whereas?
Example, you said maybe we should add 2 lawyers, and I'm.
Oh, you mean on the actual board?
Yeah, actually board. I'm sorry.
Oh, okay. So there are versions of civilian oversight boards that do that specifically say that you must have a member who is this, and must have a member who represents this, must have a member who represents this, and even as I mentioned, there are some versions that actually have police union members, sometimes as non-voting members of the board, to be there. That was not included in the original version of 208, nor is it included in the committee substitute or the proposed changes.
I bring up the suggestion because I'm hoping that at the end of the day that there can be a harmonious agreement to accept it. I know there'll be flat out, this person wanted this group wanted that, and everybody's not. I can't see everybody getting exactly what they want, but if everybody can walk away with the win-win strategy where no one lost and what everyone was trying to achieve would be a good thing.
We agree that would be a good thing.
I personally kind of like the supermajority effect on moving forward in investigations, and there are a couple places. You wanted simple majority. I think there's value in supermajorities. Because even at the Board of Aldermen, if we want to suspend the rules, we need a supermajority to suspend the rules. If we want to sell property, we need a supermajority to sell property. So that's just my comment on the value of having a supermajority. Because I don't think that if you had a meeting and you had 3 people and for other reasons somebody else could not be at the meeting, something slides through that had unintended consequences, and then of course create internal problems.
Yeah, so there are some sections in the bill where it refers to a majority of those present, and then there's some section that refer to just a majority. So the difference would basically be 3 versus 4 votes. And then there was a section that, as you referred to, as a supermajority, which would be 5 of the 7. The only thing I would have an issue with about that would be that it requires a supermajority to do some of the things that the board is designed to do, like the very purpose of the board is to do, and it requires a supermajority. I think that might be a little bit beyond, but I appreciate the comment, though. That's something.
Well, it
to consider.
encourages people to show up.
Well, it's not just about who shows up. It's about who's a member, where those groups come from. So, for instance, and that would even get down to, for instance, the sub-districts. There are enough sub-districts that are made up of, wards that are very conservative and, all white versus other districts that are made up of wards that are pretty much all black. So you're almost setting yourself up to have conflict and maybe sometimes not agreement. So sometimes it's just easier for the workings of the board to have 4 of the 7 than 5 of the 7 required, at least for what you would think is the basic function of the board.
This is my last question. I think I missed the explanation. You talked about the COB shall determine by majority of its members. There was a deletion of at a meeting where a quorum is present and based on preponderance of evidence. I'm just not clear the need to strike out. I mean, you can't conduct business without a quorum, so I wasn't sure why you would suggest to delete that from the original board bill.
It has to do with the number of votes. So a majority of those present, so a quorum would be 4 of the 7, and a majority of those present would be 3. If it's just a majority of the board instead of those present, it would be 4. So it actually raises the number from 3 to 4.
If you had 4 members, the majority is 3 on a vote, right?
Right.
And that's a quorum, 4.
Right.
And that's what originally 208 suggests, is that by a majority of its members at a meeting where a quorum, which would be 4, is present. So I'm confused, or maybe I'm just misinterpreting.
Which section are you in, I'm sorry?
Would be on this page 24, not that we're discussing the committee substitute.
Mm-hmm.
And we're not.
We're not. All right, I see. Right, so the difference between a majority of its members versus a majority of its members at a meeting where there's a quorum is a majority of its members is 4. A majority of the members where a quorum is present is 3.
It's 7 members, right?
Right.
So a quorum is 4.
Correct. So a majority of 4 is 3.
Right.
And
that's the majority of its members. No, okay, I got you.
Right.
I'm so used to a majority of its members present. That's where I missed it. I inserted a word in there that wasn't there.
Right. So it's like here when you got to get 15. Like when we have to get 15, even if there's only 17 people in the room.
Got it. Okay. I just had a cognitive delay going on right there. But thank you. And again, it's my hope that, this process can move in a way where there's not a lot of animosity amongst groups of people.
Yeah, we don't want to see a repeat of last week.
Okay. Alderman Carter. Finally.
Right. And I'm sorry if some of my questions already have been asked. I had to step out and use the restroom. So.
Thanks for sharing.
And I only have 3.
That's called TMI.
So I agree with a majority of the stuff that you are trying to do. And we can't talk about the committee sub, but what's your thoughts? Except for one thing. How did you come up with the age 25? I think that it was 18.
It was 18 before, right?
And I would just like to say, you are, to apply to be an officer, I think the age is 21. And so, I just wanted to know how you came up with the age.
The age 25 was kind of based upon some other civilian oversight boards around the country. To be a member of the Board of Aldermen and be on the Public Safety Committee, therefore, that's the age restriction.
I think that
the difference, there's been talk about, the difference between 18, 21, or 25.
Would you be opposed to drop to 21? Because I think that we have a lot of folks younger than 25 that may be filing a ton of complaints. I haven't looked at the numbers, but I think I read somewhere that a majority of the folks that had complaints against the police were between the ages of 18 and 25, or 18 and 28. It was something like that.
Mm-hmm.
Yeah, you can find anything on Twitter, so I'm not sure if I read it there and it was a fact, or if I read it somewhere else. But I know that we would love to have every age group, basically, to have a say-so in how things are ran, and made sure that they had a seat at the table as well. So that age deal was a big deal to me.
Yeah, and I'm not opposed to that. I would just say that the thought is that the more power you give the board, the more restrictions you should have about who could be on it.
Right.
The less power, less restrictions on who could be on it. But yeah, I'm open to that.
Okay. And how far would you be able to go back to file a complaint? Let's say would I be able to say that back in 1986 I was harassed by the police and I want to file a complaint now, and we look into that? Or is it
there was a
year, 6 months?
Yeah, there was a time limit. Let me see if I can find that. If the chairman knows.
Yeah, I didn't see it in there, and that's why I wanted to ask.
Yeah, the thought is that once it's enacted, you can't go back.
Oh.
Right, from my remembrance.
Okay, so it's just like from the day forth.
Right.
Okay. And last but not least, the subpoena power. What do you think? What do you think this bill does without subpoena power versus with it? What's the importance of the subpoena power?
I think the subpoena power is important because it guarantees the board access to all the information. And keeping in mind that the only real power of a civilian oversight board is to make recommendations and policy recommendations to the chief. It is important for those opinions and recommendations to be as well informed as possible. And in order to guarantee that it has a well-informed policy recommendation and a well-informed investigation based upon all the facts, subpoena power guarantees that it will have access to all that information. And so I think that's why it's important. I think if we leave it just up to the chief to supply at will information, then first that puts into question the independence of the board.
Right.
And then it puts in question whether or not they have actually had access to all the information to make an informed decision.
Okay. On page 8, the piece that you X'd out about the mayor may nominate any qualified person, and you probably already explained this, but what was the reasoning behind that? You just don't trust this selection process, or who he'll choose, or what?
No. The point was that the current version of the bill goes to a great extent to establish the COB districts, to create a nomination process, to create these districts of wards where the aldermen can work among themselves to come up with nominees and then submit those to the mayor. And then all of that is potentially done away with in one sentence where it says that all the mayor actually has to do is look at that list, consider it for a few moments, and then pick who he wants to pick. So my concern was that we go through all the process of this nomination and recommendation, but then that it does not have to be followed, and so it doesn't, again, really have any absolute power or authority, that nomination or recommendation process. So, as I talked about with the alderman from the 22nd, is that to me it should be either one or the other. So either we're leaving it up to the mayor to appoint, or we are going to do this nomination and recommendation procedure, and that's who he picks from. But if we do the nomination and recommendation procedure, and he's still free to pick who he wants. And I think over the course of time, what you'll find is the executive branch is choosing who they want.
All right. Thanks. Am I free to make a comment?
Yes, Jim.
Hey, I just think that some of the changes that you mentioned, they are changes that we should take in effect. I come from a place in the State House where we don't fear vetoes. We send millions, well, not millions, but a few bills directly to the governor to see how he would react. And so vetoes don't scare me. But I believe that some of our colleagues may fear that. So, I understand that we have to take everything in effect, and every group and how everyone feels. But at the end of the day, I think that if we are going to pass something that's supposed to protect civilians, I think that we need to pass something with teeth. So, thank you.
Okay. Alderwoman Ingracia.
Thank you, Mr. Chairman. As an original co-signer on this bill, I do have an interest in seeing something passed. And while we do have a severability clause written into either the original bill or the proposed changes, when there are too many legal issues, sometimes the courts will not just take one out and let the law stand. They will just strike the entire thing. And I guess I'm just concerned that, we have the opportunity to pass something that makes sense to most people, or we have the opportunity or the risk that we will be tied up in litigation. We will have no form of civilian review for multiple years on end. I share some of the same concerns with the alderman from the 20th with respect to Garrity protections, as well as the subpoena issues. And I'm curious, do you have a copy of the correspondence you shared with the Attorney General's office?
I do. I can ask the clerk to make that available and disseminate it to the committee and to all members.
Okay, yeah, that would be great. And I'm curious, I've got a copy here. Who did you speak with at the Attorney General's office?
So our correspondence was with Ms. Linda Lemke.
Okay.
And the actual Attorney General herself, but Linda Lemke.
Okay, all right. So I have an email that she sent to you that states that she wanted to make sure there was no confusion with respect to her analysis, and that, you know, the opinion that you gave that we can grant subpoena power was beyond the scope of the research that she provided, and that there are significant legal questions with respect to whether or not the board has the ability to grant subpoena power to other agencies or entities. I think it's pretty specifically spells out in the charter that it's for committees of the Board of Aldermen only, and that it was her opinion that the interpretation should be left to the City Councilor's office in that regard.
Yeah.
So is that the opinion to which you're referring, or are you referring to a different opinion?
No, I'll send you the opinion from her last week. There are actually 2 different emails and a correspondence with others in the Attorney General's office. Now, what I understand is that when the Post-Dispatch ran that opinion yesterday, and then we made that opinion available to the mayor's office, that there were quick conversations between the mayor's office and the Missouri Attorney General's office.
Mm-hmm.
And I had heard that there was an email sent back from Ms. Lemke that tried to backtrack on her earlier opinion. So I'd be very interested in having follow-up conversations with Ms. Lemke and actually getting something further in writing from the Attorney General's office. But the statement that we had from the Attorney General was very firm, very clear, and in fact it is quoted in the article that ran in the, on stltoday.com yesterday. And so I understand for political reasons why the Attorney General may want to defer to the Mayor's office and the City Council's office and may not get in the middle of a St. Louis City fight. But we'll be following up with them today, tomorrow, and over the weekend.
Okay, so you're saying you did not receive then the email that she sent you last night?
I've heard it. I have not seen it yet.
Okay. All right. Yeah. And again, I am an original co-sponsor on this. I just would like to see something pass and not have this tied up in litigation for multiple years. And would also, as the Alderwoman from the 28th mentioned, be more than happy to sit down and discuss any further changes, because I was not aware that this was going to be coming into my mailbox last night.
Sure. And I understand your sentiment, and that is expressed by others here too. The idea of just passing something, and I would say that many municipalities have just passed something in the name of civilian oversight, including the city of Ferguson. I think our citizens expect us to do more than just pass something. If it's called a civilian oversight board, it should have real oversight authority. And so we should try to make it as strong as possible. But taking into consideration all, especially the sponsors and co-sponsors' concerns, I think I'm confident that we'll be able to work something out over the next few days and be able to pass something before the end of the session.
Thank you. No further questions.
Alderwoman Green.
So a couple of questions. Going back to the selection process. So if once, we do have people selected onto the Citizen Oversight Board, what happens if, say, circumstances change around somebody who's on that board, or we feel like they're not being objective, or what mechanisms are there in place to recall or remove somebody from that board that we feel is not effectively serving on it?
Yeah, that's a good question. So the terms are probably the first balance there. They do have defined terms, and if it's deemed they did not effectively do their duties over that period, then they would not be renominated or approved, I think. But as far as specific language on the removal of officers, neither version had that.
Okay. I would just say that that's something that I would like to see as well, so that if there is something that arises where, there is public outcry or upset over somebody who is on the board because of actions that they've taken either as a part of the board or in their personal life, that there's that ability to, have that aired before waiting for the next appointment cycle. The last thing is more of a comment. I just don't want the, perfect to be the enemy of the good. And so I do see, the reason for having subpoena power, and I share the concerns of a lot of others here that this will end up tied up in litigation and then we have nothing there in the process. So could there be a process where we pass a bill that does not have that and then do some kind of follow-up that takes that into account so that we have something in place during the time where we may end up litigating that piece of it?
Yeah, so there are a lot of different options and possibilities. And I think it can go down into maybe three camps here. Those that want the strongest possible bill with subpoena power, those that are in the middle who want something passed, even if it is not very strong, and then those that just absolutely oppose anything that would give it teeth or subpoena power. So for those that are on the strong or the middle, there are options. We can pass it with subpoena power, pass it not with subpoena power. We can separately try to add subpoena power later. We can put the question to the voters and try to get it spelled out in the city charter specifically to give it subpoena power, which is a longer process. So there are different options. But then I think you also have that one group that just don't want it to have subpoena power and would oppose any effort at all to give it that teeth or any other additional teeth. I think there are enough of us that want to see the strongest possible one that we can pass. I would like to see it with subpoena power. I think today was an opportunity to lay it all out as far as clear language about how to make it stronger. And now is the time when we kind of take the pulse of the committee and other aldermen and see who lines up where and see what we can get past this session.
Okay. No further questions. Thank you.
Mm-hmm. Okay. Are there any other questions from members of the committee? If not, Alderman Green, did you want to just talk a little bit about your thoughts and ideas in relationship to the nomination process for you?
Okay.
Mm-hmm. We're still talking about Board Bill 208. We're not talking about committee substitute, just general thoughts and ideas in relationship to it.
Another possible change.
Yeah, another possible change. Mm-hmm.
There's two.
Just another idea that she has. Alderman Green. Mm-hmm. We all have it. So just, your general thoughts on the changes.
Okay.
Mm-hmm.
So you've heard me say several times that my concern has really been in the selection process and ensuring that we have the most amount of community input into that selection process. And so, what I've been working on is basically an amendment that would bring more transparency to that process and less political discretion. So what would be proposed is essentially having a publicized rubric with the expectations that we are looking for people who sit on the COB, so that as people are applying or submitting their application, they know what we're looking for. So we're being transparent up front with what our expectations are. Provide an opportunity for people to talk about what their background is, what it is that they would bring to the committee, and also ask for letters of recommendation from community groups or people residing within the district that they would be representing. So again, it's that citizen input piece into the selection process. And then once all of that application material is given to the Board of Aldermen members who are in each district, then they would basically grade them based upon the rubric and send their recommendations over to the mayor, who would then use the same transparent process with a rubric to make his final determination or final recommendation back to the board to approve. We would still have the public comment section, like we had said before, but I think it would standardize the process. So, because one of my concerns is that every one of the districts uses their own process to determine who they're nominating, and I think it's important that everybody's on a level playing field throughout each, and then in that we're not just making these political appointments, but we're really choosing people that are going to be representative of the communities that they are being appointed to represent. So, I'm sure it's not perfect in where it is at the moment, but the goal is to bring more transparency to that process and more opportunity for public input and public engagement throughout the selection process.
Any thoughts or comments from members of the committee? Alderman Carter? Yes, sir.
Yeah. So this would create a rubric, and in the rubric it would basically have like level of education and what they've done in the community, and what else? What are you thinking?
It's yet to be determined, but I think what I would envision happening is, in the application we have some background information, general things, employment, involvement in the community, things like that. A couple of questions dealing with trying to get around their thought process and how, if given a large amount of information that is potentially conflicting, how would you go about synthesizing that information, so we can tell a little bit more how people think, and that when they're thrown into this, they have that ability. So I think the criteria in the rubric is yet to be determined, but it would standardize the process.
Does that complete you, Alderman? Do you have another question or comment?
Yeah, no, that's it.
Okay. Alderman Boyd?
Sure. Alderman from the 15th take questions.
Mm-hmm.
Okay, so talk a little bit about the rating scale and what you envision, I guess, because my first thought and concern would be if I recommended somebody who didn't score as well in my cluster as I would have hoped. So is there a cutoff score, or what do you envision with that?
Papers.
I come to this with a background in education, and so I'm going to preface that. And it's pretty standard in the education field to give a rubric before you give any kind of assignment, so that the person completing the assignment knows what the expectations are. So examples would be, when you hand out a rubric, you don't just say, meets expectations, doesn't meet expectations, but there's actually examples in that rubric of what we're looking for, so that as people are filling out that application, they know what the questions mean, they know what the expectations are, so that they will score well. That makes sense. That they know what the expectation is going into it.
So do you envision this rubric would be something that's fairly basic, that the very lay person would be able to score well? Because my first thought would be maybe someone who's highly educated and has a wealth of experience and who's 50 years old may exceed expectations than somebody who's 21 years old, but offer a lot of value to the discussion.
Right. And I think that all goes into determining what criteria we're using as part of the rubric. So knowing that life experiences have equal weight to educational experiences, and that somebody may have a PhD, but somebody else's life experiences may be just as valuable to the board. And so I think that's yet to be determined, exactly what all of those criteria would look like. But we have outlined that we are looking for people who are objective. We are looking for people with kind of a basic amount of education, and this would just be a way of evenly evaluating all applications that come to us.
Okay, thank you. No further questions.
Okay. Alderman Schmidt.
So the task force is Public Safety Committee persons appointed by the chair, and designated representatives, Director of Public Safety. I could see this as a real positive in terms of having the consistency. I think based on many persons' experiences in various parts of the country with regard to exercises of various rights and so forth, that it could potentially become used as a basis of limiting who can serve on it. So I think we also have to be concerned about that. I do applaud you for the first time I can ever remember, putting in the word rubric in a piece of legislation. So we now have the educational and the legislative combined. But I think we just need to be a bit cautious, because we heard testimony about some folks who sort of wanted to put a well, let me just say it. When people went to the ballot, there was a test to see whether you had the right to vote or not, okay? So we want to be clear that while we want to have some basis on this that's consistent, perhaps, that we don't want to necessarily eliminate people from the table of doing this oversight. So I think it could go a couple different ways.
And I completely agree with that, and was cognizant of that. The first draft of this, we're asking as part of the application process for, a resume, and then, I went back and had a conversation with a few and said, you know what, a lot of people don't have resumes, but they can write about what their life experiences are. Without putting that into that form. So I completely agree with you on that front. And so I think the key is when, the rating scale is designed to standardize the process, that we're looking at it with that lens and making sure that somebody with, no high school diploma versus somebody who, has a PhD has an equal chance at getting on this board, if they are somebody that the community that they are supposed to represent supports and wants to see in that position.
Okay. I mean, the other thing is sort of this doesn't put anybody on a ballot. Some people would have liked to have seen folks on a ballot. There certainly wouldn't be a rubric other than, like maybe age and number of years and those kind of things. So I'm just, and then there were others who testified who wanted to have a whole series of qualifications. I just think we need to be cautious about that.
Right. And I look at this as kind of the middle ground in that when you do put somebody on the ballot, yes, there's only certain, age requirements to get yourself on the ballot, but your bio, your life experiences, your rubric is the citizens that are electing you. All of that stuff is put out there for them to make a judgment and then go to the polls and vote on that. I think when we just have a system that is only appointed by elected officials, it takes the citizens out of the process when this is supposed to be their board. And
this is designed to bring the citizens back in?
Yes. So this is designed to bring them in, because what it's outlining is the letters of support need to be coming from community members or community organizations within the district that they're wanting to represent. It's bringing more transparency to the process so that the public can look back at how scores were given and how people were chosen and know that it wasn't just because we happen to have personal relationships with somebody who wanted on this board, that they were actually qualified and they met certain expectations that can then the public can see.
Okay. Any other questions from members of the committee? Did you have any other comments on this, Alderman?
Just it's not perfect yet, but this is something I'm committed to working on. It's the piece that has concerned me the most. So if there's other feedback, I would appreciate it.
Okay. Are there other comments on Board Bill 208? Anything else?
I will only say that, so now that we have everything out, we've had our first lengthy conversation as a committee. The public has had an opportunity to comment. I think over the next few days we'll kind of touch bases to see where everybody is, what they would like to see, what level of support are for the changes. Try to construct a bill based upon those changes, those recommended changes, and the support for it. I think we have enough time to pass a bill that I think will at least be a step in the right direction. We have another board meeting next week. I asked the chair to possibly call another meeting of the committee next week. We can come together and see the results of those conversations over the next few days.
Okay. Well, we're looking towards Monday, 10 o'clock for our next meeting. But it'll be on the schedule. Okay, if there's no other discussion, surely.
I really would like to see more time to discuss this. I mean, today is Wednesday. Monday to have another meeting. Some of this is just coming forward. Other people's schedules may not allow for them to be at a meeting to be heard. So I'm not sure if it's a good idea to necessarily have, because my thought would be then that we voting on this Monday. Would that be your intent to have this voted on if we have a meeting on Monday?
We'll see.
Being as transparent as possible with everybody, and we're not, trying to do something and move it too fast where some people don't have an opportunity for true input and buy-in.
Right.
That's my concern.
Right.
Since we're talking about transparency.
No, I appreciate those comments. I think we have a lot of time for conversations. I'm open anytime. Give me a call. And I think now that we've had a public meeting and have made these changes and recommendations known not only to the committee members but to everyone, that we will receive a lot of comment from people on both sides of the issue. But that being said, I think we do want to see something passed soon, at least make an effort to make a step in the right direction. And these conversations about civilian oversight have been going on for years. And I don't think we've proposed anything that has not been at one time or another discussed or proposed. It's been going on for a very long time.
Okay. All right. With that, that completes our meeting. Our meeting's adjourned.
Thank you.
It's not on the phone.
It's not the hot seat, it's like the